Fresh matter.
Yes.
Lord, MFA 2021, my lord, it's for release amount. The petitioner is the only claimant, my lord. She has been diagnosed for cancer, hence urgency, please. Lord, these are for the hearing on IES. Hearing on IES. MFA for release amount. ಇಲ್ಲ ಸರ್ ಇದು ಬೇರೆ ಇದು similar.
Claimant said for releasing the amount.
Non-compliance of office objections for first time, serial number 1, Ravi B. Patil. Serial number 2, Subhas Mallapur.
Also, this case was wrongly linked with the other connected matters. Also. It was delinked on 30th 2024 itself. Yes, ma'am. Yes, ma'am. No matters. By wrongly they have deposited before the tribunal, and that is all. They had wrongly deposited before the
Deposited Allah. See, you had made submission. Or who had made the submission? MFA was filed in the year 2015.
Yes, ma'am.
Huh?
Yes,
There
ma'am.
were other claim petitions also. So we
So,
had directed you
the-
to publish information.
Yes.
Whether you satisfied the claim amount in the other matters.
That those
Satisfied,
yes,
then how is this appeal maintainable?
not those are from a different company. Not these are not connected with this company. Those are ICICI cases. Madam.
Club by
Where is the information given by the office? As directed on the previous occasion, office has put up a note stating that the value of the subject matter of the present appeal is less than
No deal,
rupees
madam.
15 lakhs.
No DL ಅಂತ ಹೇಳಿ. Charge sheet 3 181 ಹಾಕಿದಾರ ಅಂತ ಹಾಕಿದ್ವಿ ಅಷ್ಟೇ.
Huh?
Charge sheet 3 181 ಹಾಕಿದಾರೆ ನೋ ಡಿಎಲ್ ಅಂತ ಹಾಕಿದ್ವಿ ಅಷ್ಟೇ. ಅಂತ ಬರೀ
ಅಂತ ಮಾಡೋದಿಲ್ಲ. ಈಗ ಪೇ ಅಂಡ್ ರಿಕವರ್ ಬರುತ್ತೆ ಆದ್ರೆ.
ಹೌದು.
Anyway, see, we can't
Yes.
because it's a subject matter that is
Yes.
Single
yes, learn it single. Go make subject matter. So, accordingly, this appeal may be listed before the learned single.
ಡಿಸ್ಮಿಸ್ ಆಗಿ ರಿಕಾಲ್ ಹಾಕಿರೋ ಇದು ಡಿವಿಷನ್ ಬೆಂಚ್ ಮುಂದೆ ಡಿಸ್ಮಿಸ್ ಆಗ್ಬಿಟ್ಟು ಅದನ್ನ ರಿಕಾಲ್ ಹಾಕಿದೆ. ರಿಕಾಲ್ ಆಗಿ ರೆಸ್ಟೋರ್ ಮಾಡಿ ಅಲ್ಲಿ ಕಳಿಸಿ. ರಿಕಾಲ್ ಅಪ್ಲಿಕೇಶನ್ ಇತ್ತು ಅದು ಕಂಡರೇಷನ್ ಆಫ್ ಡಿಲೇನು ಪ್ಲಸ್ ರಿಕಾಲಿಂಗ್ ಆಗಿದೆ.
Our last sentence. However, by order dated 30th of August 2024, this appeal was dismissed for non-prosecution.
No, 18 long before, not on 18.
ಬೇರೆದಾಯ್ತು 9/3/2018.
Yes.
Since steps were not taken. Within the time granted by this court. Full stop. IAS number
1/2024.
1 and 2 of 2024 have
2 bar
been filed,
2024. ಒಂದು delay ಕಂಡೋನು ಒಂದು recall.
seeking continuation of delay of 1,444 days in filing the application for recall. Full stop. ಏನ್ರಿ ಹೇಳಿದ್ದೀರಾ for delay?
I was left over.
Will impose costs. We have gone through the affidavit filed along with the application seeking continuation of delay. Full stop. Although we are not satisfied with the explanation sought to be offered, comma, nevertheless, we find that the claimants have filed execution petition and are pressing for payment of the award amount. Stop. A ground has been raised by the appellant insurance company regarding liability.
Yes. Oh,
Stop. Therefore, comma, we are of the opinion that the delay may be condoned by imposing costs. Stop. Next paragraph. Accordingly, delay is condoned and application for recall of order dated 9/3/2018 is allowed, comma, while imposing cost of ₹5,000 on the appellant insurance company. Stop. Cost shall be paid to within a period of 2 weeks from today. Full stop. Next paragraph. After costs are paid and acknowledgement for the same is furnished in the office, comma, this matter will be listed before the learned single judge. Yes.
Serial number 3, Sangan Gowda V. Biradar.
My lords, week's time may be granted, my lord. Respondent. My lords.
Huh?
In this case, my lords, I seek time, my lords. But,
IA number 1 of 2023. For what?
my lords, IN number 1 is that, my lords, impleading application. May I state, my lord? My lords,
For impleading.
yes, my lords. One, my lords, respondent number 4, impleading respondent number 4, Nuranda Swami.
Who is that?
My lords, he is actually, my lords, earlier beneficiary, my lords, given, my lords, award amount earlier, my lords, but he was not made in party
Hmm.
by the, my lords, Lord, the beneficiary of the acquisition.
So notice has been ordered, not taken steps.
No, my lord, I, 1 week salto.
Huh?
I'm taking steps, my lord. One request, my lord, that may not be necessary because, my lord, the dispute between, my lord, that Guru Nurandaya Swami and, my lord, present plaintiff was there in a civil dispute. RA, my lord, are disposed of, and, my lord, it is held that, my lord, the present claimants are the owners of the property which is acquired. At the time of at the time of my lord's accusation.
But
The
payment has been made to that.
Yes, my
person.
lord, that person. Yes, my lord. The award was passed, my lord, in his name. There
Ah.
was a dispute saying that, my lord, his name was wrongly entered in Narwar, and, my lord, he got the payment. For that, my lord, there was a civil dispute which ended, my lord, in my favor. Thereafter, it was remitted back, and after remand, my lord, it was again, my lord, disposed of in appeal, my lord, in my favor.
Hmm.
The present status is I am, my lord, held to be the owner. After
What
the
about
reference,
What about the compensation amount paid?
no, the SLO award is paid. Now, my lord, we are in issue regarding, my lord, the reference court award. My lord, they are.
That compensation award is paid to that person.
Yes, ಅಲ್ಲ ಅವ್ರು dispute ಮಾಡ್ತಾ ಇಲ್ಲ. My lord, this is a situation.
You are going to ask for the amount.
Yes, my lord, I am going to ask for the amount. He is the one who has taken the land, my lord, from me. And, my lord, he is the beneficiary who is supposed to pay the amount. The rival claimant, my lord, is not before this court. He is not, my lord, contesting or claiming, my lord, the compensation. The beneficiary says we will not pay you because we believe somebody else is the owner.
Correct. See, compensation amount is already paid to that person.
Yes.
Are you not going to claim?
My lord,
Are you not going to
Yes.
file an execution case against them? That now the order is passed in your favor.
yes.
Are you not going to ask for payment of compensation?
I will ask for payment of compensation
Then
which
they
is
have to recover it
enhanced,
from him.
which is enhanced, not, my lord, the original award.
Why?
The enhanced amount, my lord, is the.
What should happen to the original amount?
Lord, that's a dispute between me and, my lord, that Guru Nurandaya Swami, whose favor, my lord, the award is passed. Lord, they have deposited, they have cleared their, my lord, debt insofar as that is concerned.
They have cleared to whom?
Allah, it's paid to, my lord, that person. I will have to recover it from him. I will have to recover it from him, my lord, if I'm claiming, my lord, the award which is passed by the SLO. The amount paid by the SLO, if I want to, my lord, get back, I will have to, my lord, catch hold of that person. Lord, they cannot come and say we will not pay you the enhanced amount because somebody else also has a claim. That does not lie in their mouth. Yes.
Let him come. Let him say that dispute regarding the receipt of the award amount is only between me and this person, and I will not contest the matter. If an execution case is filed, I will redeposit and ಅವ್ರು ಹೇಳಬೇಕು.
Allala, one ನಿಮಿಷ, we have not.
See, you are going to file an execution case.
Yes.
For what amount?
For the enhanced.
Entire amount.
Illa, I will.
Why would you give up the claim regarding the?
Because my claim insofar as SLO award amount does not lie here. That, my lord, I cannot claim in the execution filed against, my lord, court award. I can only claim, my lord, execution against what is awarded by the reference court. That is, my lord, the redetermined amount. I cannot claim, my lord, what is, my lord, award passed by the SLO. Your lordships may, my lord, note that, my lord, or take my submission that I will not be.
Notice has already been issued.
It has been issued because the dispute was pending. This is, my lord, settled on 23rd of August. At that time, my lord, when the notice was issued, the RA was pending.
Let him come. We will hear him and then record this and
Yes.
say the implement of that person is not necessary. Only after hearing that person. It cannot be done now without issuing notice.
Let them take.
Notice has already been issued. They were only required to take steps. Today the matters come up since steps have been not taken.
Notice was issued, my lord, under the circumstances when the dispute between myself and that party was pending. Lord, if your lordships feel that, my lord, is necessary to be heard, my lord, then.
Notice over.
Finally, a week's time is granted to the appellant to take steps for service of notice on IA number 1 of 2023. Yes.
Much.
CL number 4, VV.
My lord,
Prakash
my lord, I
Anganwadi.
appear for appellant in this case, my lord. Yesterday we have paid the process also, my lord, and I have filed an application seeking permission of this honorable court to take out a paper publication, my lord. I apologize, my lord. Last time I couldn't appear before this honorable court, my lord, for some personal inconvenience, my lords. Yesterday I have paid the process, my lord.
Learned counsel for the appellant submits that steps have been taken for service of notice.
My lord,
Yesterday in the
Yes.
office.
Yes, my lord.
Stop office to verify and issue notice.
My lord, application for seeking permission of the take out paper publication also filed, my lord, because the.
ಹಂಗಾಗಲ್ಲ 3 ಸರಿ ಆಗ್ಬೇಕು. ಈ ಸರಿ ಹೋಗಿ ಬರ್ಲಿ. Yes.
Great.
CL number 5, Mahantesh Patil.
My lord, 2 weeks time for
My lord, since
Filing paperwork,
two
madam.
thousand twenty-two, they are dragging the matter and they are not even ready to take steps and do the needful.
no, my lord, already
So they have
respondent,
taken interim order. The-
respondent number 9
Now-
service was not issued, my lord, but alternative services paper published, my lord, they are taken.
On filing of amended cost title.
Yes, my lord. And paper book was filing, my lord. 2 weeks time for paper filing.
My lord, since 22,
ಫಸ್ಟ್ ಈ ರೆಕಾರ್ಡ್ಸ್ ಅಲ್ಲಿ ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡ್ಬೇಕು.
ಇವತ್ ಮಾಡ್ತೀನಿ,
ಆಮೇಲೆ
ಇವತ್ ಕೇಸ್ ಡಿಲೇ ಆಗಿರೋದು ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 9 ಸಲುವಾಗಿ, my lord. ಅವ್ರಿಗೆ ನೋಟಿಸ್ ಮುಟ್ಟಿದಿಲ್ಲ, ಆಲ್ಟರ್ನೇಟಿವ್ ತಗೊಂಡು ಪೇಪರ್ ಅಲ್ಲಿ ಪಬ್ಲಿಷ್ ಮಾಡಿ ಇದ್ ಮಾಡಿದೆ. ಕೋರ್ಟ್ ಲಾಸ್ಟ್ ಡೇಟ್ ಅಲ್ಲಿ ಅದನ್ನ ಸಫಿಶಿಯಂಟ್ ಅಂತ ಹೇಳಿ ತಗೊಂಡಿತ್ತು.
learned counsel for the appellant is permitted to carry out the amendment in the cost title during the course of the day. Please do it now.
Yes, ma'am.
Paper book,
2 weeks time, my lord.
finally 2 weeks are granted at the request
date
of
may be given your
learned
honor.
counsel for the appellant to furnish paper book containing the amended cost title. Yes. Huh?
ಕಾಂಪ್ರಮೈಸ್ ಆಗಂಗಿದ್ರೆ ಲೋಕ ಅದಾಲತ್ಗಳಲ್ಲಿ ಪಾರ್ಟಿಷನ್ ಸೂಟ್ ಇದೆ.
Yes, my lord.
ಕಳ್ಸೋದಾ? Huh? Please call your senior.
Yes, ma'am.
Please
For
call your
class.
senior. Pass over.
ಲಾರ್ಡ್ ಅವರು ಲಾಸ್ಟ್ ಟೈಮ್ ಇಲ್ಲಿ ಬಂದು ಅಪಿಯರ್ ಆಗಿದ್ದಾರೆ, ಅವ್ರು ಆಗಲ್ ಮೇಲೆ ಲಾರ್ಡ್ ನಮ್ ಸೇರ್ ನಮ್ಗೆ ಕೊಡ್ಲಿಕ್ಕೆ ಅವ್ರು ರೆಡಿ ಇಲ್ಲ. ಇವನ್ FDP ಹಾಕೊಂಡಿದ್ದೆ ಅದ್ರಲ್ಲಿ ಹಳ್ಳಿಗೆ ಹೋದ್ರು ಹೊಲ ಹಳ್ಳಿಗೆ ಕೊಟ್ಟಿಲ್ಲ ಸರ್.
ಆಯ್ತು ರೀ, ಈ ಲೋಕದ ಟ್ರೈ ಮಾಡಿ.
ಪಾರ್ಟಿಷನ್ ಸೂಟ್
ಮಾಡಿ.
ಡಿಗ್ರಿ ಆಗೈತಲ್ರಿ ಅವ್ರ
ಇಲ್ಲಿ
ಪರವಾಗಿ. ಮತ್ತೆ ಏನಾದ್ರು ನಿಮ್ ಲೀಗಲ್ ಪಾಯಿಂಟ್ಸ್ ಇದ್ರೆ ಹೇಳ್ಬೋದು ಅಷ್ಟೇ.
ನೀವು ಯು ಆರ್ ನಾಟ್ ರೆಡಿ ಟು ಗೋ ಫಾರ್ ಕಾಂಪ್ರಮೈಸ್ ಬಿಕಾಸ್
ಇಲ್ಲ ನಾನ್ ಪ್ರೆಸೆಂಟ್ ಇಟ್ಟಿನಿ ಸರ್ ಲಾಸ್ಟ್ ಟೈಮ್.
ಪ್ಲೀಸ್ ಗೋ ದೆನ್.
ಆಯ್ತು.
Matter stands referred to the
My lord, please
ensuing
pass
Lok
over.
Adalat. Yes.
ಒಂದ್ ಡೇಟ್ ಎಲ್ಲಿ ಎಂದಂತ.
ಲೋಕ್ ಅದಾಲತ್ ಮುಂದೆ ಹೋಗ್ರಿ,
ನೆಕ್ಸ್ಟ್ 14th
ಟ್ರೈ ಮಾಡ್ರಿ.
ಆಯ್ತು.
Yes.
CL number 6, Arun Kumar Amargundappa.
Please, my lords, appearing for the learned counsel for the appellant, my lords.
Yes.
My lords.
This
IA,
copy is
I
served.
have served, my lord. Office objection is banded. I have already served.
Ah.
I received the copy. This matter pertaining to bank. my lord.
Yes, yes.
please. One is how much interest?
ಎಷ್ಟು ಬಂದಿದೆ ಬ್ಯಾಂಕ್ಗೆ?
In my
How
lord,
much more is to be recovered?
illa, bro, I apologize, my lord. I have tried my best level. Since there is no guidelines, this scheme cannot be extended. If
Sir,
any
We
scheme
will
has,
issue directions. Please tell us what is the amount to be recovered still. We want to know what is the amount because we have directed and they have deposited.
Yes.
Now you have taken the money.
no, my lord, at the direction
We
of the,
will not wait for you.
no, my
We
lord,
will issue directions. We are asking you, what is the amount recoverable by them as of now?
no, if the extension was not given scheme, my lord.
Please, sir, we are asking you in terms of the directions issued by this court, they have deposited the amount. You have collected it. We want to know what is the balance amount to be recovered from them.
No, my lord, my submission, my lord, my instructions are there. That a writ petition itself is not maintainable, my lord,
Why?
in view of the Supreme Court judgment.
Huh?
In view of the Supreme
We'll
Court
cons-
judgment.
We'll consider all that. The very purpose for which we have given all these directions is to find out what is the balance amount.
My lord,
And if they are prepared to pay it, what is the difficulty?
Scheme ಇಲ್ಲ, my lord.
Adin bidi, sir, you don't worry about the OTS. We are asking you, what is the balance recoverable?
When there is no OTS, I cannot accept, my lord.
OTS bitbidi, sir, OTS beda.
OTS bit
We are asking you, what is the balance amount recoverable? If they are ready to pay it, they'll pay it.
The OTS bit, there is one.
OTS bitbidi.
So I have given my reply, my lord. I'll see what
Now,
is that.
after collecting this amount, what is the amount recoverable?
So if your OTS have been not taken into consideration, my lord,
ಅಲ್ಲ ಈ ಮಧ್ಯದಾಗ ಅಮೌಂಟ್ ತಗೊಂಡಿದಿರಲ್ಲ ಅದು ತಗೊಂಡ್ಮೇಲೆ ಎಷ್ಟಿದೆ ಡ್ಯೂ ಅಂತ
ಇವಾಗ ರೀಸೆಟ್ ಆಗಿ ತಗೊಂಡಿದ್ರಲ್ಲ,
ಇದು
ಅದಾದ್ಮೇಲೆ ಸೇರಿಸಿ ಇವಾಗ ಎಷ್ಟು ಬ್ಯಾಲೆನ್ಸ್ ಇದೆ ಅಂತ ಹೇಳಿ ದಯವಿಟ್ಟು.
ಟುಡೇ
OTS ಒಪ್ಕೊಂಡ್ರ the amount will be different. Since OTS is not extended,
Don't worry about the OTS.
ಅದು OTS accept ಮಾಡಿದ್ರೆ 1 crore ತನ ಬರ್ತದೆ.
Huh?
It is coming at 1 crore.
Please.
After receipt of
Yes. Yes,
the amount that was that has happened recently.
yes. If OTS failed, if OTS is not considered. Because this was NPA was done in 17, my lord. And the claim, the writ petition is filed basing upon Punjab Haryana judgment. That was been set aside by the apex court. Therefore, from the day one, we are saying that the writ
My lord,
petition itself is
Let
not.
them
maintained.
produce, please. My lord, as rightly, my lords, this only court quoted, without the OTS also, this cannot be 1 crore 25 lakhs now. 75 lakh, at the time of OTS, they said 90 lakhs pending, and OTS was for 75. Now entire amount is paid, and at 25 lakhs is deposited. That is withdrawn, my lords. I only pray your lords may direct them to produce the statement of accounts. They cannot fudge the statement of accounts, say now it's 1 crore 25 lakhs.
Perfect. Yeah, what is that additional information that you have placed now?
No, this court has directed to furnish, my lord, representation to the bank. Because it cannot be considered here, a fresh representation being given to the bank, my lord. They have given representation, my lord. Then for that, my lord, the bank has replied it.
In fact, they were duty bound to produce the correct statement of accounts, my lords, accounting for all the amounts received and giving deductions. Instead of that, they come with the IEA, my lords. Your lords may kindly keep this, my lords, IEA, and direct them to produce the correct statement of accounts. The IEA has nothing more except stating that our representation is rejected.
Please come to paragraph number 3 of page number 11 of the information that you have given, additional information.
11, my lord.
Ah.
During night 20, when the bank came with the one-time settlement, SBI 20.
Even according to you,
Yes, ma'am.
in 2020,
Yes, ma'am.
the outstanding amount was 97,84,517.
Yes, my lord.
We are not talking of the OTS.
Yes,
We are
ma'am.
talking of the actual amount,
Yes, my lord.
97,84,000.
Yes, my lord.
Out of that, 47 lakhs were paid.
Yes, ma'am. So this figure, my lord, the interest was not carried over once some account is
Correct.
interest will be not charged, my lord.
Cannot.
Exactly, my lord.
Cannot charge.
If it is from 2017, on that amount, 97 interest charges is added, my lord.
On top of that,
Yes.
what is the amount paid?
25.
My
On
lord,
top of that,
as
again
on
55.
today, my lord, 75 lakh.
Huh?
As on today, my lord, including the interest accrued.
They have recorded that.
Yes,
Please.
ಇಲ್ಲ. 28 lakh, my lord, some 239 or 339 amount, my lord, that was made before, deposit made before this honorable court, along with interest accrued, my lord. 28 lakh.
Huh?
28 lakh, that is 23,013 rupees. That is with regard to deposit.
What is the amount you received recently from the registry?
28,000,
28 lakh.
28 lakhs
28 lakhs.
Yes.
and some odd.
28 lakhs. So please calculate and see
Amen.
and give us a statement of memo of calculation, then we will consider. Perfect.
If OTS is not considered, what will the?
Yes.
My lord, response number one is State Bank of India, my lords, required to be fair. The State Bank of India, my lords, is an instrumentality of the state, premier institute, banking institute.
We find that even in terms of the latest communication dated 1/8/2024 made by the respondent bank to the appellant herein. As on 2020, the outstanding amount was rupees 97,84,517. Full stop. It is admitted that in terms of the OTS settlement, although the appellant was required to pay 73,38,388, nevertheless, only 47 lakhs were paid. Full stop. Therefore, it is stated that the outstanding amount was rupees 26,38,388. Full stop. In our previous order, we have noticed that in terms of the directions issued by this court, the appellant had deposited certain amounts before the registry of this court. And
25 lakh.
in terms of the directions issued by this court, the respondent bank has collected a sum of rupees
28 lakhs,
8 lakhs,
23,013
23,013. On yavattu?
It is on
5/11/2024. 5/11/2024. Full stop. Next para. We therefore direct the respondent bank to furnish a memo of calculation stating what is the outstanding amount due from the appellant. Release this matter on 21st of November.
21st.
26th.
20th also early state budget.
26.
ಅದೇನ್ರಿ ಬರೀ ಮೆಮೋ ಆಫ್ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಕೊಡ್ಬೇಕಷ್ಟೇ.
ಕಳಿಸ್ತೀನಿ.
May I also point out one important aspect, my lords. This amount of 47 lakhs which was paid, they say it's kept under suspense account without any interest.
10 lakh, 10 lakh.
Everything
other-
under suspense, and they don't even account for it. Please.
As and when they give a memo of calculation, you point
Please.
out the defect in that.
I'm most grateful.
We will-
Please,
we will consider the matter.
Please, my lords. I'm grateful. Earliest date possible, my lords.
21st of November.
Please, grateful.
Yes.
Seal number 7, Nitesh Padia.
Lordship, I have filed a counter affidavit against the objections filed by respondent. Your Lordship, as per their own compliance affidavit which they have filed.
Huh?
As per their compliance affidavit which they have filed.
Huh.
Lordship may kindly peruse page number 14, Your Lordship.
14 of
Their affidavit, compliance affidavit filed by respondents. Have given the chart wherein regarding.
what is this matter about?
Your Lordship, this is regarding, there was a filing of a writ petition. He was orally terminated.
Huh?
He was, the complainant was orally terminated, your lordship, which was challenged before a single bench, and the court ordered for his reinstatement.
Hmm.
And it also directed it to release all his arrears which were pending, including all the TA and DS, everything. After that, after there was no complaints, contempt was filed. And in this contempt, they have filed a complaints affidavit stated in the page number 14, where they have stated that ನೌಕರರು ಸದರಿ ಮಾಹೆಯಲ್ಲಿ ಕರ್ತವ್ಯಕ್ಕೆ ಹಾಜರಾದ ದಿನಗಳು. They have given the details of the working days of the complainant. Your lordship, in this, at serial number 3, April 2022, they have said 0. And March, your lordship, March 2023, April 2023, May 2023. Along with that, July 2022, August 2022, September 2022. They have said that I have not worked for these days. In fact, I have worked for all these days, and I have submitted my all work diary reports, tentative reports, travel claims, everything. Again, still they have shown that I have not worked for the said periods. With respect to the last 3 months, that is March 2023, April 2023, May 2023, wherein I have worked, and even they have paid the salary for the said months. That I have annexed in my counter affidavit, your lordship, annexure G, page number 16.
Yes. Have you gone through the?
Please, my lord.
Yes. What is your?
Kindly see the order of the learned single judge, my lord. What my learned friend says that for reinstatement and only the prayer is before the learned single is that, my lord, for consideration of representation submitted by the petitioner, my lord, complainant. Honorable single judge was directed. May I read, my lord, page number 5, my lord, of the
representation was given by the writ petitioner on 6/4/2023.
considered his
Accordingly, writ petition is disposed of by directing the respondents, particularly respondent number 7, to
Please.
consider the representation of the petitioner dated 6/4/2023 in accordance with law.
Please.
When this court directs the respondent to consider the representation, it is not a formality. The respondent shall consider the representation within a period of 4 weeks.
Please.
Yes.
My lord, thereafter, my lord, after passing of this order, my lord, respondent authority issued a notice to the complainant, my lord, by holding an inquiry, my lord. Kindly see the page number 5 of my affidavit, my lord, compliance affidavit, at page number annexure R1, my lord. He is called for the inquiry, my lord, where he is not placed any records. ಅಲ್ಲಿ ಬಂದು ಅವ್ರ ಜೊತೆ ಜಗಳ ಆಡ್ಬಿಟ್ಟು ಪೇಜ್ ನಂಬರ್ 5 annexure R1, my lord. ಮೇ ರೀಡ್, ಮೈ ಲಾರ್ಡ್. ಸೆಕೆಂಡ್ ಪ್ಯಾರಾ, ಫಸ್ಟ್ ಪ್ಯಾರಾದೊಂದು ಏನೇನ್ ಪ್ರೇಯರ್ ಇದೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಐ ವಿಲ್ ರೀಡ್ ಫಸ್ಟ್ ಪ್ಯಾರಾ ಆಲ್ಸೋ. ಉಲ್ಲೇಖ 1ರ ಮಾನ್ಯ ಘನ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಆದೇಶದಂತೆ ಉಲ್ಲೇಖ 2ರ ಮೂಲಕ ಸ್ವಚ್ಛ ಭಾರತ ಮಿಷನ್ ಯೋಜನೆಯಡಿ ಜಿಲ್ಲಾ ಸಮಾಲೋಚಕರನ್ನಾಗಿ ಕಾರ್ಯನಿರ್ವಹಿಸಿದ ಬಾಕಿ ವೇತನ ಹಾಗೂ 3% ಹೆಚ್ಚುವರಿ ವೇತನ ಮತ್ತು TADA ಬಿಡುಗಡೆ ಮಾಡುವಂತೆ ಮನವಿ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಮುಂದುವರೆದು ಉಲ್ಲೇಖ 3ರಲ್ಲಿ ಗೌರವಾನ್ವಿತ ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯವು ರಿಟ್ ಪಿಟಿಷನ್ ಸಂಖ್ಯೆ ಸೋ ಮೂಲಕ ತೀರ್ಪು ಪ್ರಕಟಿಸಿ ಅದರಂತೆ ಫೆಬ್ರವರಿ 22ರಿಂದ ಮೇ 20 ಬಾಕಿ ವೇತನ ಸೋ ಶೇಕಡ 3% ಹೆಚ್ಚುವರಿ ವೇತನ ಮತ್ತು 46 ಮಾಹೆಗಳ TADA ಪಾವತಿಸುವಂತೆ ಆದೇಶಿಸಿರುತ್ತಾರೆ. ಮಾನ್ಯ ನ್ಯಾಯಾಲಯದ ಆದೇಶದಂತೆ ಮುಖ್ಯ ಕಾರ್ಯನಿರ್ವಾಹಕ ಅಧಿಕಾರಿಗಳ ನಿರ್ದೇಶನದ ಮೇರೆಗೆ ಉಲ್ಲೇಖ 4ರ ಈ ಕಚೇರಿ ನೋಟಿಸ್ ಮೂಲಕ ದಿನಾಂಕ 28/2/2024 ಸದರಿ ನಿಮ್ಮನ್ನು ಕಚೇರಿಗೆ ಕರೆಸಿ ವೇತನ ಹಾಗೂ ಭತ್ಯೆಗಳ ಬಾಕಿ ಕುರಿತು ಈ ಕಚೇರಿಯ ಉಪ ಕಾರ್ಯದರ್ಶಿಗಳು ಹಾಗೂ ಯೋಜನಾ ನಿರ್ದೇಶಕರು ಜಿಲ್ಲಾ ಪಂಚಾಯತ್ ರಾಯಚೂರವರ ಸಮ್ಮುಖದಲ್ಲಿ ಜರುಗಿದ ಸಭೆಯಲ್ಲಿಯೂ ಸಹ ಹಿರಿಯ ಅಧಿಕಾರಿಗಳೊಂದಿಗೆ ವಾಗ್ವಾದಕ್ಕಿಳಿದು ದುರ್ವರ್ತನೆಯನ್ನು ಪ್ರದರ್ಶಿಸಿರುತ್ತೀರಿ. ಆದಾಗ್ಯೂ ಉಲ್ಲೇಖ 5ರ ನಡವಳಿ ತೀರ್ಮಾನದಂತೆ ಈ ಕೆಳಗಂಟೆ ಕ್ರಮ ವಹಿಸಲಾಗಿದೆ. ಫೆಬ್ರವರಿ 2022ರಿಂದ ಮೇ 2023ರವರೆಗಿನ ಬಾಕಿ ವೇತನಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಕಚೇರಿಗೆ ಹಾಜರಾದ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸಿದ ದಿನಗಳಿಗೆ ವೇತನ ಪಾವತಿಸುವಂತೆ ಈಗಾಗಲೇ ಉಲ್ಲೇಖ 6ರಲ್ಲಿ ಕಾರ್ಯನಿರ್ವಾಹಕ ಅಭಿಯಂತರರು ಗ್ರಾಮೀಣ ಕುಡಿಯುವ ನೀರು ನೈರ್ಮಲ್ಯ ವಿಭಾಗ ರಾಯಚೂರವರಿಗೆ ತಿಳಿಸಲಾಗಿತ್ತು. ಸದರಿಯವರು ಈಗಾಗಲೇ 93 ದಿನಗಳ ವೇತನ ದಿನಾಂಕ 20/8/2024ರಿಂದ ಪಾವತಿಸಲಾಗಿದೆ. UTR ಸಂಖ್ಯೆ ಸೋ. ಮುಂದುವರೆದು ದಿನಾಂಕ 21/5/2021ರಿಂದ ಶೇಕಡ 3% ಹೆಚ್ಚುವರಿ ವೇತನವನ್ನು ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸಿದ ದಿನಗಳಿಗೆ ಮಾತ್ರ ಈಗಾಗಲೇ ನೀಡಲು ವೇತನಕ್ಕೆ ಹೆಚ್ಚುವರಿಯಾಗಿ ದಿನಾಂಕ 21/5/2021ರಿಂದ 25 ಮಾಹೆಗಳವರೆಗೆ ಪಾವತಿಸಲು ಉಲ್ಲೇಖ 7ರಲ್ಲಿ ಕಾರ್ಯನಿರ್ವಾಹಕ ಅಭಿಯಂತರರು ಗ್ರಾಮೀಣ ಕುಡಿಯುವ ನೀರು ಮತ್ತು ನೈರ್ಮಲ್ಯ ವಿಭಾಗ ರಾಯಚೂರವರಿಗೆ ತಿಳಿಸಲಾಗಿತ್ತು. ಅದರಂತೆ ಸದರಿಯವರು ಉಲ್ಲೇಖ 9ರಲ್ಲಿ ಖಜಾನೆ ಟೋಕನ್ ಸಂಖ್ಯೆ ಸೋ ಮೂಲಕ ದಿನಾಂಕ 31/8/2024ರಂದು ಪಾವತಿಸಲು ಕ್ರಮ ವಹಿಸಲಾಗಿದೆ. ಮಾಹೆ 46 ಮಾಹೆಗಳ TADಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಸರ್ಕಾರದ ಪತ್ರ ಸಂಖ್ಯೆ ದಿನಾಂಕ 19/8/2019 ಜಿಲ್ಲಾ ಸಂಯೋಜಕರು ಟೆಂಟೇಟಿವ್ ಟೂರ್ ಪ್ಲಾನ್ ಅನ್ನು ಈ ಕಚೇರಿಯಿಂದ ನಿಯಮಾನುಸಾರ ಅನುಮೋದನೆ ಪಡೆದುಕೊಂಡು ಅದರಂತೆ ತದನಂತರ ದಿನಚರಿಗಳಲ್ಲಿ ವರ್ಡ್ ಮೈ ಲಾರ್ಡ್ ವಾಟ್ ದೇ ಆರ್ ಪ್ಲೇಸಿಂಗ್ ಬಿಫೋರ್ ದಿಸ್ ಆನರಬಲ್ ಕೋರ್ಟ್ ಪಡೆದುಕೊಂಡು ತದನಂತರ ದಿನಚರಿಯಲ್ಲಿ ಸಲ್ಲಿಸಿ ಪ್ರವಾಸ ಕೈಗೊಂಡ ಬಿಲ್ಲುಗಳನ್ನು ಬಿಲ್ ವೋಚರ್ಗಳನ್ನು ಸಂಬಂಧಪಟ್ಟ ಪ್ರಾಧಿಕಾರದಿಂದ ದೃಢೀಕರಿಸಿ ಈ ಕಚೇರಿಗೆ ಸಲ್ಲಿಸಿ TADಗಳನ್ನು ನಿಯಮಾನುಸಾರ ಪಡೆಯಬಹುದಿತ್ತು. ಆದರೆ ಸದರಿ ಮೇಲೆ ತಿಳಿಸಿದ ದಾಖಲೆಗಳಲ್ಲಿ ತತ್ಸಂಬಂಧಿತ ದಾಖಲೆಗಳನ್ನು ನೀವು ಈ ಕಚೇರಿಗೆ ಸಲ್ಲಿಸದೇ ಇರುವುದರಿಂದ TADಗಳನ್ನು ಪಾವತಿಸಲು ನಿಯಮದಲ್ಲಿ ಅವಕಾಶವಿರುವುದಿಲ್ಲ. ಈಗ ಅವ್ರೇನ್ ಹೇಳ್ತಾರೆ, ಟೂರ್ ಪ್ಲಾನ್ ಕೊಟ್ಟಿದ್ದು ಕರೆಕ್ಟ್. ಟೂರ್ ಪ್ಲಾನ್ ಕೊಟ್ಟಾದ್ಮೇಲೆ ಅದನ್ನ ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡಿ ಅಲಾಂಗ್ ವಿತ್ ರಿಸಿಪ್ಟ್ he has to place before the authority, my lord. ಕೋರ್ಟ್ ಇಲ್ಲಿ ಈಗ ಕೌಂಟರ್ ಅಫಿಡವಿಟ್ ಅಲ್ಲಿ ಟೂರ್ ಪ್ಲಾನ್ ಅನ್ನು ಅಪ್ರೂವ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಟೂರ್ ಪ್ಲಾನ್ ಅಪ್ರೂವ್ ಕೊಟ್ಟಿದ್ಮೇಲೆ ಅವ್ರು ಅಪಿಯರೂ ಆಗಿಲ್ಲ, ಕೆಲಸನೂ ಮಾಡಿಲ್ಲ, ಅದ್ರ ಜೊತೆಗಿರುವಂತ ಯಾವ್ದು TADಗೆ ಸಂಬಂಧಪಟ್ಟಂತ ರಿಸಿಟ್ಗಳು ಯಾವುದನ್ನು ಪ್ಲೇಸ್ ಮಾಡ್ದೇನೆ ಐದರ್ ಬಿಫೋರ್ ದಿಸ್ ಕೋರ್ಟ್ ಆರ್ ಬಿಫೋರ್ ದಿ ಎನ್ಕ್ವೈರಿ ಅಥಾರಿಟಿ. ಔಟ್ ಆಫ್ 46 ಮಂತ್ ಅವ್ರು ಕೇಳ್ತಾ ಇದ್ದಾರೆ. 46 ಮಂತ್ ಅಲ್ಲಿ 3 months ಟೂರ್ ಪ್ಲಾನ್ ಅಪ್ರೂವಲ್ ಕೊಡ್ತಾ ಇದ್ದಾರೆ. ಕ್ಲೈಮ್ ಮಾಡ್ತಾ ಇರೋದು 46 ಮಂತ್ ಅಂತ. ಈವನ್ ಬಿಫೋರ್ ದಿಸ್ ಕೋರ್ಟ್ ಆಲ್ಸೋ ಅವ್ರ ಆಟಿಟ್ಯೂಡ್ ಹೆಂಗಿದೆ ಅಂದ್ರೆ, ವಿಥೌಟ್ ವರ್ಕಿಂಗ್ ಮೈ ಲಾರ್ಡ್, he don't want to work in the office, my lord. ಎಲ್ರನ್ನು ಆಫೀಸರ್ಸ್ ನ ಬ್ಲಾಕ್ ಮೇಲ್ ಮಾಡಿ ಹೆದರ್ಸಿ ಸ್ಯಾಲರಿ ಕ್ಲೈಮ್ ಮಾಡುವಂತದ್ದು. ವರ್ಡ್ ಯೂಸ್ಡ್ ಆಸ್ 46 ಮಂತ್ ಬಟ್ ಡಾಕ್ಯುಮೆಂಟ್ ಪ್ಲೇಸ್ಡ್ ಫಾರ್ ಓನ್ಲಿ 3 months. ಅಲ್ಲಿ ಆಫೀಸ್ ಅಲ್ಲಿ ನೋಟಿಸ್ ಕೊಟ್ಟು ಕರೆದಾಗ್ಲೂ ಕೂಡ ಈಸ್ ನಾಟ್ ರೆಡಿ ಟು ಸಬ್ಮಿಟ್ ಎನಿ ಡಾಕ್ಯುಮೆಂಟ್, ಮೈ ಲಾರ್ಡ್. And prayer before the learned single judges to consider representation, that was considered, my lord.
The directions issued by the learned single judge.
Yes.
We are required to consider whether there is compliance or not.
Yes.
Now you please read the directions to the learned single judge once again. It is only that they should consider your representation in accordance with law.
And as not as a formality, your lordship.
Correct.
They have specifically
So
stated.
they have said that what are the steps that they have taken, and they have made the payment.
Yes.
This court cannot go into the further disputes.
Yes. Lordship, I would like to,
Even under the writ jurisdiction,
yes,
disputed questions cannot be entertained.
yes,
If you are so interested, you'll have to go to the civil court.
your lordship, kindly peruse my statement of objections.
Yes, Barkole.
Your lordship, I have at page number 7, your lordship, I have submitted. Your lordship, there is a work diary report that I have.
You liberty, sir. They have issued you a notice, and before making the payments, they have also made a communication stating what are the reasons for which some of your claims are not complied.
Your lordship, even though considering all those
Therefore,
things, as per their own.
you place the requisite information, and we will give you liberty. It will be still open for you to place all the material. If you place that material, there we will direct them to consider.
Lordship, one
Otherwise,
submission,
you'll have to go to the
only
civil
one
court.
submission, your lordship, only one
Okay.
submission. I have submitted, along with the tentative plan, I have submitted my work diary report also, wherein I have stated where all I have visited on those days.
Ah.
I have submitted that work diary report also.
Hmm.
And they say that I have not worked for all those months, wherein I have submitted, all those are documented.
They have stated very clearly in the communication.
Where is the receipts, my lord? In support to that,
But
my
their
lord.
own compliance affidavit shows certain loopholes, your lordship, where they say that I have not worked, and they themselves have made a payment for those months,
Hmm.
for which they have said that I have not worked for.
Hmm.
Their compliance affidavit itself
That
shows
we
that
should take as
just only by to overcome the contempt proceedings, they have filed this complaint.
accordance with
evidence.
law, whatever material you are required to place, you please place. We will grant you liberty. And the directions are issued that they should consider your representation in accordance with law.
Lordship, and their compliance affidavit itself, it has some certain wrongdoings in their own.
You have put it in writing, sir.
No, I have for the.
Whatever stand that they have taken, they have put in writing, and they have said that these are the information that you have not given.
Your lordship, I
And,
have given.
Have that information.
For-
you please-
And even
all
we
the
are issued a
TAD and
notice, my
everything I
lord.
have submitted my report.
Prior to
If
passing of
one
the
more
order,
date
we are
is
issued
given, your
notice.
lordship, I will produce the documents relating to the TAD allowances where I have submitted the reports also. I will produce that also, your
See,
lordship.
they have said, yeah,
My lord,
ತರ ದಿನಚರಿಯನ್ನು ಸಲ್ಲಿಸಿ ಪ್ರವಾಸ ಕೈಗೊಂಡ ಸಂಬಂಧಿತ ಬಿಲ್ ವೋಚರ್ಗಳನ್ನು ಸಂಬಂಧಪಟ್ಟ ಪ್ರಾಧಿಕಾರದಿಂದ ದೃಢೀಕರಿಸಿ ಈ ಕಚೇರಿಗೆ ಸಲ್ಲಿಸಿ.
Your lordship, if you kindly, your lordship.
Please do it. If you do it, we will direct them to consider.
But your lordship, in their own complaints affidavit, they have stated wrong contentions that I have not worked, wherein I have producing a documents that I have worked for the said period. I have submitted my work report, work diary report, tentative tour plan, everything.
ಅಲ್ಲಲ್ಲ 46
Though after working, I have worked for
they are
those periods,
claiming
I
as
have been paid
40
for those periods. They said that I have not worked and I have not been paid. Their own complaints affidavit shows that.
In the writ jurisdiction, we try to do all this. That is the difficulty. At the initial stage itself, if you are declined to entertain, if you are directed, you go and approach the competent authority or go to a civil court. Yalla sari hogti.
Lordship, even though
All disputed questions on writ jurisdiction.
your
What
lordship
can we do?
kindly peruse this judgment, your lordship,
No,
is
sir.
regarding consideration. Only a formality consideration will be
No, no,
not
no.
enough, your lordship.
No, no,
Honorable
it's not
Apex
a
Court has held
formality.
that.
They have given a detailed information as to why they have considered only a part of it and why they have not considered the other
But
part.
their detailed information itself is
It is
wrong, your
open for
lordship.
you please go, place the requisite material and get it done. Otherwise, you go to civil court.
And these observations may be made in the orders.
Complaints affidavit has been filed at the hands of the executive officer of the Taluk Panchayat, Lingsugur, along with endorsement dated 2/9/2024 at annexure R1. Full stop. Learned counsel for the respondent Panchayat submits that in terms of the directions issued by the learned single judge, the respondents have considered the claim of the complainant. Full stop. In fact, notice dated 28/2/2024 was issued to the complainant subsequent to the orders passed in the writ petition. Full stop. The complainant appeared before the concerned and an inquiry was held into the matter while seeking all information from the complainant as well as the office. Full stop. After verifying the records,
even in that proceedings
whatever
is
payment has to be made to the complainant has been made. Full stop. Insofar as the rejection of the claim for TA and DA for a certain period, the authorities have rejected the claim of the complainant while stating that the requisite certified documents have not been produced by the complainant. Full stop. Next para. Learned counsel for the complainant submits that the learned single judge has specifically directed that the consideration should not be a mere formality. Full stop. Next para. We have heard the learned counsels for the complainant, the learned counsel for the respondents, and have perused the complaints affidavit as well as the rejoinder filed on behalf of the claimant, a complainant. Full stop. We are of the considered opinion that in such matters where claim of payment of arrears of salary would arise, normally a writ petition should not be entertained. Full stop. Disputed questions as are sought to be brought out before this court cannot be considered under writ jurisdiction. Full stop. Nevertheless, having regard to the directions issued by the learned single judge, that the respondents shall consider the representation given by the writ petitioner and take steps in accordance with law, comma, the respondents have conducted an inquiry, got all the information from the complainant as well as the office and have verified the records, full stop. Thereafter, the payments have been made, full stop. Therefore, comma, we are of the considered opinion that the directions issued by the learned single judge have been complied, full stop. Next para.
Lordship on submission.
However, we also grant liberty to the complainant to further place any material as pointed out in the endorsement dated 2/9/2024 before the concerned authority. And if such material is placed, comma, the respondents shall reconsider the claim in respect of the TA and DA. Full stop. If the documents satisfy the requirement, comma, then the respondents shall further make the payment in accordance with law. Full stop. It is also open for the complainant to approach the civil court or any other competent authority for redressal of his grievance. The content petition is accordingly
Lordship,
closed.
there may be,
Mm,
there shall be an
Grateful.
observation regarding to these aspects, your Lordship, wherein they have said that I have not worked and I have been
That
paid
is
for
why
those
we have said
periods.
all
Because the
real
representation is regarding to that period itself, your Lordship.
Grateful.
becomes disputed question, sir. We cannot go into all this. Please
Ah.
understand. Yes.
Like this. My lord, I apologize, 21 but 22nd.
22nd Friday ಆಗೋಗುತ್ತೆ. ಬೇಡ.
Monday.
ನೋಡೋಣ, ಲೆಟ್ ಯು ಪ್ಲೀಸ್ ಕಮ್, ವಿಲ್ ಸಿ.
Availability ಇಲ್ಲ.
ಅಲ್ಲಿ ನೀವಿಲ್ಲ ಅಂತಂದ್ರೆ ನಿಮ್ಮ ಕೊಲಿಗ್ ಕಳ್ಸಿ.
ಅದಕ್ಕೆ ಆ ದೃಷ್ಟಿಯಿಂದ ಹೇಳಿ.
ಕಳ್ಸ್ಕೊಡಿ. We only want the information. We are not going to decide the case that day. Yes.
CL number 8, Liaquat Farid Mustaq.
In this
Very
matter,
good.
my lord, I'll take notice for response 1 and 2, my lord. In persons of the order of the learned single judge, my lord, we issued the endorsement to the, my lord, complainant. May I pass on, my lord, this. There is a direction, my lord, page number 9, my lord, learned single judge. A mandamus is issued directing the respondent 2 and 3 to consult the application dated 12/3/2024, submitted by the petitioner as per.
Station of the revenue records.
Yes, my lord.
Ah.
This is, my lord, we, my lord, issued the endorsement, my lord, on 21/10/2024.
Ah.
Requesting him to furnish the document and death certificate of the concerned person. Second para, my lord. ಆದರೆ ನೀವು ಸಲ್ಲಿಸಿರುವ ದಾಖಲೆ ಮತ್ತು ಆದೇಶ ಪರಿಶೀಲಿಸಲಾಗಿ ಮಾನ್ಯ ನ್ಯಾಯಾಲಯದ ದೃಢೀಕೃತ ಆದೇಶ ಲಗತ್ತಿಸಿರುವುದಿಲ್ಲ ಮತ್ತು ಪ್ರಶ್ನಿತ ರಾಜಾ ಮೊಹಮ್ಮದ್ ತಂದೆ ಉಸ್ಮಾನ್ ಸಾಬ್, ಫಕೀರ್ ಸಾಬ್ ತಂದೆ ಉಸ್ಮಾನ್ ಸಾಬ್ ಮತ್ತು ಮಸ್ತನ್ ಸಾಬ್ ತಂದೆ ಸುಲೇಮಾನ್ ಸಾಬ್
ಯಾಕೆ
ಅವರ
record ಮಾಡಿಲ್ಲ?
I will furnish, my lordship.
Huh?
I already furnished to the respondent office, my lordship.
ಮಾಡಿಲ್ಲ ಅಂತಾರೆ.
subsequently, my lord, the ತಹಸೀಲ್ದಾರ್ is before.
ನಿಮ್ಮ ಹತ್ರ ಇದೆಯಾ ನಿಮ್ಮ ಅಪ್ಲಿಕೇಶನ್ ಜೊತೆಗೆ ಏನೇನು ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಸಬ್ಮಿಟ್ ಮಾಡಿದ್ರೆ ಇದೆಯಾ ನಿಮ್ಮ ಹತ್ರ?
Yes, my lordship.
Do you have the information?
Yes, my lordship. Ink page number 10, my lordship.
ಎಲ್ಲ ಕೊಟ್ಟಿದಾರ? ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದಾರೆ, death certificate.
I produced the representation with all annexures with petition copy, my lordship.
ಇದು ಕೇಳಿದ ಪ್ರಕಾರ ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದಾರೆ. ಎಲ್ಲ death certificate. Yesterday only they submitted all the documents, my lord. In process of that, my lord, we'll proceed further, my lord, issue further endorsement.
Huh?
Yesterday only they given all the documents.
Yesterday.
Yes, my lord.
No, my lordship. Yes.
And here
Before I
enclosed
submit the all documents, my lordship.
copy, ಪಹಣಿ ಅಲ್ಲ ಡೆತ್ ಸರ್ಟಿಫಿಕೇಟ್.
Death certificate to B3.
I produced, my lordship.
ಯಾವಾಗ?
Already produced, my lordship, with along with annexures, my.
ಎಲ್ಲಿದೆ? ಪ್ಲೀಸ್ ಶೋ. ನಿನ್ನೆ ಕೊಟ್ಟಿರೋದ?
Yes.
ಅಲ್ರಿ,
No, my
along
lordship.
with your application, you are not given the death certificate.
Not given.
What is the basis of your application?
My lordship, I submitted before.
What is the basis of your application, sir? that your father has passed away,
Yes, my lord.
your grandfather has passed away,
Yes, my lord.
and therefore you are entitled to get the mutation done
Yes.
on the basis of succession.
My lordship, yes, my lord.
For that purpose, you are required to furnish a copy of the death certificate
I already,
furnished along with the application.
please, my lord.
No,
I already submitted, my lordship.
ಯಾವಾಗ್ರಿ already ಅಂದ್ರೆ
21/9/24, my lordship.
This is only application.
ಡೆತ್ ಸರ್ಟಿಫಿಕೇಟ್ ಬಗ್ಗೆ ಹೇಳಿದಿರಾ ನೋಡಿ.
High Court,
You have not mentioned about the death certificate.
Yes.
Then ಅದೇ
I have enclosed High Court order copy, Pahani application, ಅಷ್ಟೇ.
Kindly week's time will be granted.
ಎನ್ನೆ ಕೊಟ್ಟಿದಾರೇನ್ರಿ?
ಬಂದಿದೆ. ಈಗ ಕೊಟ್ಟಿದ್ದಾರೆ, ಕೊಟ್ಟಿದ್ದಾರೆ.
ಅದೇನ್ರಿ ಕರೆಕ್ಟ್ ಆಗಿ ಇನ್ಫಾರ್ಮೇಶನ್ ಕಲೆಕ್ಟ್ ಮಾಡ್ಕೊಳ್ಳಲ್ರಿ ನೀವು? He is saying yes, you have given it yesterday. So what are you going to do now?
Now, my lord, will go through that, the documents, my lord, will issue the, my lord, necessary endorsement or effect the, whichever, if we entitle, my lord, will mutate his name. Otherwise, my lord, we issue the endorsement. If we not entitle, my lord, then we will issue the endorsement.
What is the law laid down regarding such application?
But once
Has to be considered?
that's, my lord, after, there is, my lord, 4 or 5 members are there, my lord. After issue of that application, my concerned party, we have to issue notice to them.
All the concerned?
Yes, my lord. Now, my lord, we are going to issue the,
If
to all
there is
the
no
person.
objection from
Then
any
only
side,
we- then only we'll-
then you are required to enter their names.
please, that one will do.
Huh?
Yes, 1 month time is required for
My
us.
lordship, they are already filed the, have no objections, all brothers.
Huh?
That has to be verified, Allah. That has to be verified.
Please, ma'am. Please.
21 issue ಮಾಡಿದ್ರೆ ಫಾರಂ ನಂಬರ್ 21 ಇನ್ನ ಮಾಡಿ 12/21
ಎಷ್ಟು ದಿವಸ ಬೇಕ್ರಿ ಇದಕ್ಕೆಲ್ಲ?
1 month.
1 month?
ಸರ್ ಇಲ್ಲಿ ಗ್ರೇಟ್ ಪೇರೆಂಟ್ಸ್ ಮೂವರ್ ಇದಾರೆ ಸರ್, ಅವ್ರ ಲೀನಿಯೇಜ್ ಎಲ್ಲ ತಗೋಬೇಕು. ಇವ್ರು ಏನ್ ಹೇಳ್ತಿದ್ದಾರೆ ಸರ್, 4 ಜನ ಸೈನ್ ಮಾಡಿ ಕೊಟ್ಟಿದ್ದಾರೆ ಸರ್, ಬಟ್ ಆಕ್ಚುಲಿ ರಿಲೀಸ್ ಡೇಟ್ ಕೊಡ್ಬೇಕು ಸರ್. ಇಟ್ ಇಸ್ ಸಿವಿಲ್ ಮ್ಯಾಟರ್ ಸರ್. ಸಿವಿಲ್
ರಿಲೀಸ್ ಅದೆಲ್ಲ ಇಲ್ಲ. ಪ್ಲೀಸ್ ಡೋಂಟ್ ಗೋ ಇಂಟು ಆಲ್ ದೋಸ್ ಥಿಂಗ್ಸ್. ಜಂಟಿಯಾಗಿ ಬರ್ಬೇಕು ಹೆಸರು.
ಸರ್
ಅವ್ರು ಒಬ್ಬರ ಹೆಸರು ಮಾಡಕ್ ಬರೋದಿಲ್ಲ.
ಈಗ ಜಂಟಿ ಆಗೈತೆ ಸರ್ ಎಲ್ಲರದು, ಅದು ಬೇಡ ಅಂತ
ಮತ್ತೆ
ಈಗ ಎಲ್ರದ್ದು ಜಂಟಿ ಆಗಿದೆ ಸರ್. ಯಾರ್ಯಾರು ಡೆತ್ ಸರ್ಟಿಫಿಕೇಟ್ ಕೊಟ್ಟಿದಾರಲ್ಲ ಸರ್, ಜಂಟಿ ಆಗಿ ಪಾಣಿ
ಖಾತೆ ಆಗಿದೆಯಾ ಆಗ್ಲೇ? ಪೌತಿ ವಾರಿಸ್ ಖಾತೆ ಆಗಿದೆಯಾ?
ಪೌತಿ ವಾರಿಸ್ ಖಾತೆ ಆಗಿಲ್ಲ ಸರ್. ಖಾತೆಯಲ್ಲಿರೋ ಎಲ್ಲರೂ ಡೆತ್ ಆಗಿದ್ದಾರೆ ಸರ್. ಸೊ ನಮ್ಮ ಅಪ್ಲಿಕೆಂಟ್ ಹೆಸರಿಗೆ ಮಾತ್ರ ಮಾಡಂತ ಹೇಳ್ತಾರೆ ಸರ್. ನಾವು ಎಲ್ಲರೂ ಯಾರ್ಯಾರು ಇದ್ದಾರೆ ಎಲ್ಲರ ಹೆಸರಿಗೆ ಮಾಡ್ತೀವಿ ಅಂತ ಹೇಳ್ತೀವಿ.
ಅಷ್ಟೇ ಮಾಡ್ಬೇಕಾಗಿರೋದು. ಒಬ್ಬರ ಹೆಸರೆಲ್ಲ ಮಾಡಕ್ ಬರೋದಿಲ್ಲ. ಅವರು ರೈಟಿಂಗ್ ಅಲ್ಲಿ ನೋ ಅಬ್ಜೆಕ್ಷನ್ ಕೊಟ್ರು ಮಾಡಕ್ ಬರೋದಿಲ್ಲ.
ಅವ್ರು ಅದನ್ನೇ ಹೇಳ್ತಾರೆ.
ದಯವಿಟ್ಟು ಅರ್ಥ ಮಾಡ್ಕೊಳ್ಳಿ.
ನೋ ಅಬ್ಜೆಕ್ಷನ್
It cannot be done. ಅದಕ್ಕೆ they have to have a partition or some document which is registered in accordance with law. You can consider it only on that basis, not by mere no objection given by others. ಹಂಗೆಲ್ಲ ಮಾಡಕ್ ಬರೋದಿಲ್ಲ.
In the
What
application,
is your claim? You want your name only to be entered?
Yes, my lordship.
ಹಂಗ್ ಮಾಡಕ್ ಬರಲ್ಲ.
our application ದಲ್ಲಿ ಇದೆ ಸ್ವಾಮಿ,
It has
authority.
to be a proper division of the property, or all of them should have released their rights in accordance with law.
Right.
Only then your name will be entered. Otherwise, no.
They have filed the no objection, my lordship, to my name is entered.
No objection ಆಗಲ್ಲ ರೀ, ಹಿಂಗ್ ಮಾಡಕ್ ಬರೋದಿಲ್ಲ. No objection to enter all their names jointly. ನಿಮ್ಮೊಬ್ಬರ ಹೆಸರು ಮಾಡಕ್ ಬರೋದಿಲ್ಲ. ಅದೆಲ್ಲ ಹಳೆ ಕಾಲ ಮುಗ್ದೋಯ್ತದು. ಇವೆಲ್ಲ ಈ ತರ ತಪ್ಪುಗಳು ಆಗತ್ತೆ ಅನ್ಬಿಟ್ಟೆ ನಾವು they have decided no, you will not. They are going to do it only in accordance with law. ಅಷ್ಟೇ. There has to be a declaration at the hands of the civil court or a document which shows that they have either given up the rights or there has been a division.
Please.
And in that division or partition, you have got this property. Otherwise, all the names of the joint owners should be entered.
That observation, my lord, will also dispose of this contempt, my lord. If not done, my lord, liberty may be given to review them.
Please.
Learned government advocate submits that an endorsement dated 21/10/2024 has been issued to the complainant, stating that the complainant is required to furnish the death certificate of his father along with the genealogical tree. Full stop. Learned government advocate submits. Who is he?
Tahsildar.
That the Tahsildar Basava Kalyan is present before the court. And on instructions, it is submitted that the application given by the complainant for entering his name in the land records pursuant to the death of his father and registered khatedar will be considered in accordance with law. Full stop. If all this information as sought is given, comma, notice will be published and thereafter action will be taken for entering the names of the legitimate legal representatives of the previous khatedar. Full stop. Next para. Recording the submission of the learned government advocate and the undertaking given by the Tahsildar Basava Kalyan, who is present in the court, comma, the contempt petition stands closed while directing the complainant to furnish all the requisite information to enable the Tahsildar to take action. Full stop. The entire exercise shall be completed as expeditiously as possible and at any rate within a period of 6 weeks
Please.
from today. Ordered accordingly.
Great.
CL number 9, Mahantesh Patil.
My lords, I appear for the respondent state in this matter, my lords.
Appear for the.
My lords, at the outset, I would my lords,
Yes.
please. My lords, on 11th Monday, my lords, I had logged in, my lords. I did not realize at 5 o'clock that the counsel for the petitioner had made a submission. I thought the matter was not taken up, my lords. So that is the reason I couldn't make my submissions, my lords. My lords have again listed it today. Please, my lords.
Senior is appearing. Jaikumar, this is pertaining to the teachers.
Yes, yes. Yes, Mr. Jaikumar Patil.
Please, my lord, as regards the subject
yes, my
matter, the lordships have already noticed the contention.
We had adjourned the matter on the last occasion,
Please,
reminding you again
please,
what was the submission made by the learned senior counsel.
please,
And we had directed you to secure instructions and make submissions.
please, my lords. I had secured instructions, my lords. On the last occasion, I was logged in. Unfortunately, I did not realize that the petitioner was making submissions, my lords. It must have been taken up at around 5 p.m., my lords. I was there. I did not realize the petitioner was making submissions. I was.
Yearly.
Please, my lords. I may read my lords' direction to the state on 15/10, my lords. Sri Learned Senior Counsel Sri Jaikumar S. Patil, appearing on behalf of the petitioner, submits that although the petitioners are aggrieved of the action of the respondent state in issuing notifications after notification, changing the rules during the course of recruitment process, nevertheless, their immediate grievance is regarding a clause imposed in the later notification restricting the rights of the petitioner for selection only in the districts where they have written the examinations. In this regard, the learned AAG seeks short accommodation to secure instruction and make submission.
Correct.
My humble submission
Yes.
is, my lords.
Yes.
the recruitment itself was district-wise recruitment, my lords. There was no change in that clause. There was no further notification issued to change that. That, my lords, is not correct. Despite that, my lords, because my lords are directed.
There has been some changes.
Illa, not with
There
regard
has been
to.
some changes.
No, my lords, not with regard to the.
Adilde irbodu, sir. But because you have made certain other changes.
Other
that
changes
has got
that.
an impact on this one. Yes.
Okay, please, I bow to my lords.
That is why that submission was made.
Please, I bow to my lords. I am yet to submit, my lords.
See, even
Lords.
according to the recent judgment of the Honorable Supreme Court, which again is a reiteration of what was earlier the law.
Please,
that
in
once-
Manjushri's judgment, please.
Once the recruitment process has commenced, no changes can be made.
Please,
Except if it is permissible under the rules itself.
please. I bow to my lords. Bow to.
Yes.
Please. Lords,
So you
on
could
merits,
not
my
have
lords.
made any changes.
No, we have
You
not.
could not have made
our
any
case-
changes to the recruitment process or the procedure.
But my humble submission is that, my lords, no changes have been made. In fact, our case has been allowed based on the observations made in Manjushri judgment, which is again upheld, upheld in the judgment of the constitution-based judgment in Tej Prakash Patak, my lords. My lords, besides that, my lords have directed us to find out whether it would be possible to accommodate these candidates who have failed to secure, secure a place in the selection list. If
Yes.
provided their marks are more than other candidates in other districts outside HK area.
Yes.
My lords, I did pursue that matter with the authorities, my lords, though they also evinced interest. The difficulty that they face is, my lord, the notification, the original notification itself, as far as government primary school teachers recruitment is concerned, it's meant to be district-wise. So that is the reason why, my lords, where district-wise recruitment is called for, examinations were also conducted district-wise, and wherever they have written the exam, they will be considered for appointment only there. That is the difficulty which we faced because that is the mandate of the notification. But having said that, if the Honorable Court were to direct us to consider, because in law, my lords, in accordance with our rules, we do not have any power to do that.
Yes,
If my
Mr.
lord-
Jaikumar Patil.
Please,
Which are the changes that they brought about?
please, I'll point out, my lord. Kindly go to page.
My lords, before I beg for my lord's forgiveness, it appears they have filed application for impleadment that is not served on me, my lords.
My lord,
Yeah.
And
now
I
they
made
have
the
served to
application
me.
for
Some
IA
of you-
number
Some
3.
of you want to implead.
Yes,
That we'll see. Yes.
propose.
And
Yes.
my lords, one more, that memo for producing comparison table, my learned friend advocate on record for the petitioner, I think is by forgotten to serve it on us. If he does serve it on us, we can.
We have served the memo.
Please, sir, you could
Earlier,
serve
what we
another
have
copy.
filed, my lords, which is already there.
Which one? No, comparison table has been served on us.
ಯಾವ್ದು?
Adu comparison table and more detail agi we have filed it, my lords. In order to,
Then.
earlier which we have filed, my lords, in order to clear,
ಅಲ್ಲ ಆಯ್ತು.
explain.
ಇದಕ್ಕೆ ಕಾಪಿ ಕೊಟ್ಟಿದ್ರಲ್ಲ ಅವ್ರಿಗೆ.
ಕೊಟ್ಟಿದ್ದೀವಿ.
ಮಿಸ್ಟರ್
ಅವ್ರಿಗೆ ಕೊಡ್ಲಾರ್ದೆ ತಗೊಳ್ಳೋದೇ ಇಲ್ಲ ಇಲ್ಲಿ ಕೆಳಗಡೆ.
GA
ಎಲ್ಲ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಅದು
ಎಲ್ಲ ಪೂರ್ತಿ ಎಲ್ಲ ಅಲ್ಲ ಕಳ್ಸ್ಬಿಟ್ಟಿದ್ದೀರಾ?
ಎಲ್ಲ ಕೊಟ್ಟಿಲ್ಲ ಸರ್, ಅದು ಹಿಂದೆ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಅಲ್ಲಲ್ಲ ನಿಮ್ಮ ಹತ್ರ ಫೈಲ್ ಇದೆಯಾ ಅಲ್ಲಿ?
ಇದೆ ಸರ್,
ಹಾ?
ಇದೆ.
ಇದ್ರಲ್ಲಿ ಇದು ಇದೆಯಾ ಇಲ್ವಾ ನೋಡಿ ಸ್ವಲ್ಪ.
ಇಲ್ಲ ಸರ್, ಇದರಲ್ಲಿ
Memo for production of comparison table. This was filed on 22nd of October.
Earlier ಏನಿತ್ತು ಅದನ್ನೇ explanation ಆಗಿ
ಇದೆ.
ಅದೇನು
ಇಲ್ಲ ನಿಮ್ಮ ಸೀಲು ಇದೆ.
2210
ಇದೆ. Your colleague has got it here.
Please, I bow to my lords. I'll obtain a copy, please.
Yes, Mr. Senior Counsel.
Please, your lordship, may kindly go to page 65. I am in 200416. Your lordship, may kindly have 200416.
What? Page number?
Page number 65, annexure A1. In that, my lord, your lordship may kindly go to page 67. Second para. Staliya Mikkulida, your lordship got it, my lord. ಸ್ಥಳೀಯ ಮಿಕ್ಕುಳಿದ ಎರಡೂ ವೃಂದಗಳಿಗೆ ಏಕಕಾಲಕ್ಕೆ ಒಂದೇ ಅಧಿಸೂಚನೆಯಲ್ಲಿ ಒಂದೇ ಇಲಾಖೆಯ ಒಂದೇ ಪದನಾಮದ ಬಹು ಆಯ್ಕೆಗೆ ಅವಕಾಶವಿಲ್ಲದ ಹುದ್ದೆಗಳನ್ನು ನೇಮಕಾತಿ ಮಾಡಿಕೊಳ್ಳುವ ಸಂದರ್ಭದಲ್ಲಿ ಮಾತ್ರ ಕೆಪಿಎಸ್ಯು ಸೇರಿದಂತೆ ಎಲ್ಲ ನೇಮಕಾತಿ ಪ್ರಾಧಿಕಾರಿಗಳು ಸ್ಥಳೀಯ ವ್ಯಕ್ತಿಗಳಿಗೆ ಈ ಕೆಳಕಂಡ ಆಯ್ಕೆಗಳನ್ನು ಒಂದೇ ಅರ್ಜಿ ನಮೂನೆಯಲ್ಲಿ ನಮೂದಿಸಿ ಒಂದೇ ಅರ್ಜಿಯಲ್ಲಿ ಆಹ್ವಾನಿಸತಕ್ಕದ್ದು. ಹೈದರಾಬಾದ್ ಕರ್ನಾಟಕ ಸ್ಥಳೀಯ ವೃಂದದ ಹುದ್ದೆಗಳಿಗೆ ಆಯ್ಕೆ ಬಯಸುವಿರಾ? ಹೌದು ಅಥವಾ ಇಲ್ಲ. 2. ಮಿಕ್ಕುಳಿದ ವೃಂದಗಳ ಹುದ್ದೆಗೆ ಅರ್ಜಿ ಸಲ್ಲಿಸಲು ಬಯಸುವಿರಾ? ಹೌದು ಅಥವಾ ಇಲ್ಲ. ಅರ್ಜಿ ಸಲ್ಲಿಸುವ ಸಮಯದಲ್ಲಿ ನೀವು ನೀಡಿರುವ ಹುದ್ದೆಗಳ ಆದ್ಯತೆಯಂತೆ ಸ್ಥಳೀಯ ಹಾಗೂ ಮಿಕ್ಕುಳಿದ, ಲೋಕಲ್ ಅಂದ್ರೆ 371J, ಮಿಕ್ಕುಳಿದ ಅಂದ್ರೆ ರೆಸಿಡಿಯರಿ, ಎರಡೂ ವೃಂದದಲ್ಲಿ ಒಂದೇ ಹುದ್ದೆಯ ಆಯ್ಕೆಗೆ ಅರ್ಹತೆ ಹೊಂದಿದಲ್ಲಿ ಯಾವ ವೃಂದದ ಹುದ್ದೆಗೆ ಆಯ್ಕೆ ಬಯಸುತ್ತೀರಿ? If you become eligible under both category, what you will say? ನೋಟ್, ಒಂದು ವೇಳೆ ಸ್ಥಳೀಯ ಅಭ್ಯರ್ಥಿಯು ಮಿಕ್ಕುಳಿದ ವೃಂದದ ಹುದ್ದೆಯನ್ನು ಆಯ್ಕೆ ಮಾಡಿಕೊಂಡು ನೇಮಕಾತಿ ಹೊಂದಿದಲ್ಲಿ 20% ರೆಸಿಡಿಯರಿಗೆ ಆಯ್ಕೆ ಆದ್ರೆ ಅಂತಹ ಅಭ್ಯರ್ಥಿಗೆ ಜಾರಿಯಲ್ಲಿರುವ ನಿಯಮದಂತೆ ತನ್ನ ಸೇವಾ ಅವಧಿಯಲ್ಲಿ ಅನುಚ್ಛೇದ 371J ಮೀಸಲಾತಿ ಸೌಲಭ್ಯವು ದೊರೆಯುವುದಿಲ್ಲ ಎಂಬುದನ್ನು ಸ್ಪಷ್ಟೀಕರಿಸಲಾಗಿದೆ. So what was said was, those persons who are eligible under 371J, if they are to opt for the remaining 20%, if they are to opt for remaining 20% and become eligible there, then they will not
be eligible for 371J in the future.
In future. Because of this, all the area covered by Hyderabad, Karnataka, that is Raichur, Gulbarga, etc., where 80% is for 371J, 20% is for residiary. Many of us who are from outside these districts applied here and took examination because 90% or even 100% of Hyderabad students would opt for 80% seats. Accordingly, results were announced in the provisional list. All these petitioners are selected in the 20% seat. Already we were selected. At this stage, they issued the notification, page 152. This is 15/6/2022. ಇದರಲ್ಲಿ ಏನ್ ಮಾಡಿದ್ರು ಅಂದ್ರೆ, ಹೈದರಾಬಾದ್ ಕರ್ನಾಟಕದವರು ಯಾವದನ್ನ ಆಪ್ಟ್ ಮಾಡ್ಕೊಂಡ್ರು ಈ ಫ್ಯೂಚರಿಗೆ ಅಫೆಕ್ಟ್ ಆಗೋದಿಲ್ಲ ಅಂತ ಹೇಳಿ ಅನ್ನೋ ಕಂಡೀಷನ್ ಅನ್ನ ತೆಗೆದು ಹಾಕ್ತೀವಿ. ಬಟ್ ಪೇಜ್ 153 ಲಾಸ್ಟ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ನೋಡ್ಬೇಕು. ದಿಸ್ ಇಸ್ ವಾಟ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಪಾಯಿಂಟೆಡ್. ಈಗಾಗಲೇ ಗೆಜೆಟೆಡ್ ಪ್ರೊಫೆಷನಲ್ ಹುದ್ದೆ
in the first page,
please,
page number 152, first page, the second paragraph, unnumbered second paragraph ಓದಿ.
ದಿನಾಂಕ 6/6/20 ಸುತ್ತೋಲೆಗೆ ಕರ್ನಾಟಕ ಭಾಗದ ಸ್ಥಳೀಯ ಅಭ್ಯರ್ಥಿಗಳಿಂದ ಹಾಗೂ ಜನಪ್ರತಿನಿಧಿಗಳಿಂದ ತೀವ್ರ ವಿರೋಧ ವ್ಯಕ್ತವಾದ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಸದರಿ ವಿಷಯವನ್ನು ನಿರ್ಣಯಕ್ಕಾಗಿ 7/5/22 ನಡೆದ ಸಚಿವ ಸಂಪುಟ ಉಪಸಮಿತಿಯ ಮುಂದೆ ಮಂಡಿಸಲಾಯಿತು. ಸಮಿತಿಯ ತೀರ್ಮಾನದಂತೆ ತಕ್ಷಣದಿಂದ ಜಾರಿಗೆ ಬರುವಂತೆ 6/6/20 ಸುತ್ತೋಲೆಯನ್ನು ಹಿಂಪಡೆಯಲಾಗಿದೆ.
So before this circular dated 15/6/2020, one ನಿಮಿಷ, before this circular dated 15/6/2022 was issued,
ಹೌದು,
the selection process was already over.
ಹೌದು. ಅದಕ್ಕಾಗಿ ಇಲ್ಲಿ ಏನ್ ಮಾಡಿದ್ದಾರೆ ಅಂದ್ರೆ ಲಾಸ್ಟ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ತಾವು ನೋಡಬೇಕು. 153 ಲಾಸ್ಟ್ ಪ್ಯಾರಾಗ್ರಾಫ್.
Yes.
In accordance with Supreme Court judgment, what they said was,
ಈಗಾಗಲೇ ಗೆಜೆಟೆಡ್ ಪ್ರೊಬೇಷನರ್ಸ್ ಹುದ್ದೆಗಳನ್ನು ಹೊರತುಪಡಿಸಿ ಒಂದೇ ಅಧಿಸೂಚನೆ ಹೊರಡಿಸಿ ನೇಮಕಾತಿ ಪ್ರಕ್ರಿಯೆ ಜಾರಿಯಲ್ಲಿ ಇರುವ ಪ್ರಕರಣಗಳಿಗೆ ಸೀಮಿತವಾಗುವಂತೆ ಮಾತ್ರ 6/6/20 ಸುತ್ತೋಲೆಯಲ್ಲಿ ನೀಡಿರುವ ನಿರ್ದೇಶನಗಳನ್ವಯ ಆಯ್ಕೆ ಪ್ರಕ್ರಿಯೆಯನ್ನು ಅಂತಿಮಗೊಳಿಸಲು ಸೂಚಿಸಲಾಗಿದೆ. ಇದನ್ನ ನಾವು ಅಪ್ಲೈ ಮಾಡೋದಿಲ್ಲ. ಫೇರ್ ಇಟ್ ಈಸ್ ಆಲ್ರೆಡಿ ಇನ್ ಪ್ರೋಗ್ರೆಸ್, ಯು ಪ್ರೊಸೀಡ್ ಅಂತ ಹೇಳಿ ಆ 15/6 ಮಾಡಿದ್ರು. ಅದಾದ್ಮೇಲೆ ಅಗೈನ್ 368 page 368 1/2/23 annexure A45 ಇದರಲ್ಲಿ ಮತ್ತೆ ಅದನ್ನೇ ಎಲ್ಲ ರೀಟ್ರೇಟ್ ಮಾಡಿ ಕೈಂಡ್ಲಿ ಗೋ ಟು 369 ಲಾಸ್ಟ್ ಪ್ಯಾರಾಗ್ರಾಫ್. ದಿನಾಂಕ 15/6/22 ಸುತ್ತೋಲೆಯ ಕೊನೆಯ ಖಂಡಿಕೆಯನ್ನು ಮಾತ್ರ ಹಿಂಪಡೆಯಲಾಗಿದ್ದು ಇನ್ನುಳಿದ ಎಲ್ಲಾ ಅಂಶಗಳು ಯಥಾವತ್ತು ಜಾರಿಯಲ್ಲಿರುತ್ತವೆ. ಅಲ್ಲೇನು ಪ್ರಕ್ರಿಯೆ ಜಾರಿಯಲ್ಲಿದ್ದದಕ್ಕೆ ಅಪ್ಲೈ ಮಾಡಬಾರ್ದು ಅಂತಿತ್ತು, ಅದನ್ನು ವಾಪಸ್ ತಗೊಂಡು. ದಿಸ್ ಈಸ್ ವಾಟ್ ಈಸ್
which means they have made it applicable to the pending process,
fair
which
selection
which is not permissible in law and even in terms of the judgments of the Supreme Court.
ಆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಕಾಪಿಯನ್ನು ಅವ್ರಿಗೆ ಕೊಟ್ಟಿದ್ದೇವೆ. ಇಲ್ಲಿ ಇಟ್ ರಿಸಲ್ಟ್ಸ್ ಇನ್ ಎ ಕ್ಲಿಯರ್ ಪ್ರೆಜುಡಿಸ್ ಟು ಅಸ್.
Correct. So is it the contention of the government that this issue has already been considered? ಯಾವ್ದೋ ಜಡ್ಜ್ಮೆಂಟ್ಸ್ ಎರಡು ಯಾವ್ದೋ ಜಡ್ಜ್ಮೆಂಟ್ಸ್ ತೋರಿಸ್ತಾ ಇದ್ರಲ್ಲ,
ಅವರು ಜಡ್ಜ್ಮೆಂಟ್ ತೋರಿಸ್ತಾ ಇದ್ದಿದ್ದು ಈ ನೋಟಿಫಿಕೇಶನ್ ಗಳನ್ನ
ಸಂಜಯ್ ಗೌಡ ಅವ್ರದೊಂದು, ಜಸ್ಟಿಸ್ ನಾಗಪ್ರಸನ್ನ
ಕೊಟ್ಟಿದ್ದೀವಿ ಸ್ವಾಮಿ.
ಸಂಜಯ್ ಗೌಡ ಅಂಡ್ ಜಸ್ಟಿಸ್ ಇದು ಅವೆರಡು ಅದನ್ನ
both are learned single judges.
ಸಿಂಗಲ್ ಜಡ್ಜಸ್, ಬಟ್ ಅಲ್ಲಿ ಡಿಫರೆಂಟ್ ಸಿಚುವೇಶನ್ ಇಟ್ ಸೆಲ್ಫ್ ಇಸ್ ಡಿಫರೆಂಟ್. ಅಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ ಇಟ್ ಈಸ್ ಸ್ಟೇಟ್ ಲೆವೆಲ್ ಸೆಲೆಕ್ಷನ್. ಅಲ್ಲಿ ನಮ್ಮ ಮೇಲೆ ರಿಸ್ಟ್ರಿಕ್ಷನ್ ಇರ್ಲಿಲ್ಲ, ನೀವು ಅಲ್ಲಿ ಹೋಗಂಗಿಲ್ಲ ಇಲ್ಲಿ ಹೋಗಂಗಿಲ್ಲ ಅಂತ.
Yes.
Therefore, court said there is no prejudice to you.
Yes, Mr. AG.
It is this prejudice that happens and the Supreme Court judgment which your lordships had pointed out.
Yes.
Whether that can be answered by the government by doing something else or they would like to take the judgment.
Yes, Mr. AG.
Please, my lords, we finished a list of authorities, my lords. The printouts of the same are not provided because I was under the, I had assumed that the matter today would be heard with regard to the provision, a creation of provision of these candidates who missed out being placed in the selection list to be considered for other districts. But on the matter of 371J itself, if the petitioners were to pursue and argue on that, my lords, my list of authorities are there, my lords. I'd like to place it on record.
Please go through the latest judgment.
Please,
which has been passed last week.
Tej Prakash Patak versus Rajasthan High Court. I think, my lords, the petitioners, my lords, have, my humble submission is, my lord, with great respect, my lords, the matter has been held in my favor. The clear paragraph 8, my lords may kindly see the reference itself.
Yes.
Tej Prakash Patak versus Rajasthan High Court, Civil Appeal number 2635 of 2013. My case before the tribunal and my case before the High Court is that my case is squarely covered by the judgment of the Honorable Supreme Court in K. Manjushri. The correctness of the K. Manjushri's judgment was questioned in this particular case, my lords, and the Constitution bench was asked to look into the correctness of that particular judgment. May I draw my lord's kind attention to paragraph number 8, which sums up the issue.
Yes.
However, in regard to changing the rules of the game, method of procedure for selection, the 3-judge bench in the reference order doubted the correctness of the decision in K. Manjushri, supra inter-alia, on the ground that it failed to notice an earlier decision, Subhash Chandra Marwa, supra. Accordingly, the reference order seeks an authoritative pronouncement in this regard from a larger bench of this court. The scope of reference is therefore limited to A, whether K. Manjushri Supra lays down the correct law, and B, whether the rules of the game, method and manner of making selection can be changed or altered after the commencement of the recruitment process. May I draw my lord's kind attention to the conclusions of the court, my lord, so that I would not take much of my lord's time.
If it is permissible in the extant rules,
exactly.
the notification which is not contrary to the extant rules.
My lords, what has happened?
These are the
correct. That is also there.
conditions.
And
The rider.
conclusion number
So
3 may
therefore,
be
you will have to point out from the rules.
Please.
Whether such change is permissible, you please point out from the rules.
Conclusion number 3, my lords may kindly see. Of
Yes.
the Honorable Supreme Court. And para 42.
Yes.
We therefore answer the reference in the following terms. 1. Recruitment process commences from the date of issuance of the advertisement calling for application and ends with the filling up of applications. 2. Eligibility criteria for being placed in the select list notified at the commencement of the recruitment process cannot be changed midway through the recruitment process unless the extant rules so permit, or the advertisement which is not contrary to the extant rules so permit. Even if such a change is permissible, the extant rules or advertisement, the change would have to meet the requirement of Article 14 of the Constitution, satisfy the non-arbitrariness. May I for a moment, please. The 2, what it says is eligibility criteria should not be changed antare. Now the eligibility criteria change madilla swami. 3, I may draw my lord's kind attention to 3. I'll be able to demonstrate. That there is no change at all made by us. The decision in K. Manjushri Supra lays down good law and is not in conflict with the decision in Subhash Chandra Marwa. Subhash Chandra Marwa deals with the right to be appointed from the select list. Right to be appointed from the select list. And there are cases, my lords, as my lords are aware, a select list is prepared. A candidate makes it to the select list, but sometimes the government decides not to appoint such people. So one such case reached the Honorable Apex Court in Subhash Chandra Marwa, where Supreme Court held that as a matter of right, you cannot claim appointment. You have a right to be considered, but you have no right for appointment itself. That is what the ratio in that case. Next, my lord. Whereas in K. Manjushri, Supra deals with the right to be placed in the second list, which is squarely covers the facts of this particular case. These two cases deal with altogether different issues. Our humble submission is, my lord, and our case state's case is that the K. Manjushri's case squarely covers the facts of this particular case, and K. Manjushri's case is clearly held that unless eligibility criteria, for example, if the eligibility criteria were to be said, no, you instead of being a graduate, you have to be a postgraduate, or your age instead of being 25, it should have been only 22. Those things come under eligibility criteria. None of that is touched. I'll be able to demonstrate, my lords. Please. Hence, my lords, this judgment is in my favor. It is in fact, this judgment is sufficient.
Please don't take a myopic view by saying it only pertains to eligibility criteria.
The Supreme Court
the question is, whether this changes that you sought to make would not touch upon the eligibility criteria is the question.
Yes, it will not. It does not.
What you are trying to say is marks, prescribed marks, educational qualification, only these are eligibility criteria anta nimma vada. That cannot be correct. Eligibility criteria would also include all those aspects which will have a bearing on the eligibility of the person to be selected. It is not just the educational qualification or the marks.
Please.
So this word eligibility criteria, you please don't try to have a narrow view of this word eligibility criteria.
Manjushri case Supreme Court
Right.
There is one other aspect.
Consider.
Kindly see the next sentence in that Supreme Court judgment, that it should pass the test of Article 14.
Correct. So that is why I am saying, just because the word eligibility criteria used there, you should not try to argue this case, saying, no, we have not tampered with the eligibility criteria. What do you mean by eligibility criteria then? Is it only the prescription of the marks and the educational qualification? No.
Eligibility criteria.
All the aspects of the matter which touch upon the eligibility of the person to be selected.
Please.
Which would also include.
Eligibility.
Which would also include which would also include this aspect of the matter that is sought to be raised by the learned senior counsel.
Please.
Prima facie.
Please. My lord, that is the case before my lords. That is their case is
Master.
that there is a change in the eligibility criteria. Our case is that there is no change in the eligibility criteria.
If they are if they are able to make out a case,
Please.
that if there was no such change in the subsequent circulars, we would not have been affected.
Yeah, may I, see, my humble submission is, my lords. What has happened is, examinations have been conducted. Not only this district-wise primary school teachers, even assistant professors examinations was conducted. As my lords are aware, my lords in Vimlakshi's case have laid down. In fact, that is the first case on 371J, subject to correction, my lords, where my lords have beautifully gone through the object of 371J, Article 371J, the governor's powers to pass orders, and the manner in which the reservation has to be implemented. In pursuance of that, my lords, yes, we have issued notifications. What has happened in the notification which is there before my lords? The selection, the option was given to candidates to choose either HK or non-HK, to HK students. Non-HK students had nothing to do with it. They have no right to say that they were even prejudiced to begin with. It is my option which category I would apply for. But the difficulty was, my lords, there, my lords, I have placed, my lord, may kindly see my list of authorities, please. Other Ramesh Ramalli, Constitutional Bench judgment, where they have clearly says, if a candidate from a reserved category, like in this case, the HK category, HK reserved category, secures more marks than a candidate who is other candidates who come from the open category, he should, as a rule, be placed in the open category, because that will make it will open up more seats for students or aspirants from reserve category. That is the law laid down by the Honorable Supreme Court. And
I have understood what is the issue.
Please.
And I am also aware that I have passed an order in respect of this 371J.
Please, Vimlakshi's case, please.
And what is the law laid down, I am aware.
Please.
Now, having regard to all this,
please,
he'll have to look into the grievance sought to be made out by the petitioners.
How so?
Or appellants, if it's a appeal, appellant.
Petition.
All that they are saying is,
consider them for their case for other districts.
See, if you had implemented the recruitment process in terms of the original circular, there was no difficulty for them. It is because you made certain changes during the process and after the selection list was announced, they have placed in certain difficulty. So court is now required to consider whether the judgments of the Honorable Supreme Court, the Manjushri Agli, Subhash Chandra Marwar Agli, the latest judgment other Agli, whatever, whether it would come within the teeth of the mischief pointed out in all these cases. That is, once the process of recruitment has commenced, if you make any changes in the recruitment process that would affect rights of any of the applicant, then it is a matter which can be considered by the courts. They have clearly used the word. It should muster the Article 14 of the Constitution of India.
Test of Article 14.
So we can't take a very myopic view merely because the word eligibility criteria is used there. You can't try to argue the matter saying no, we have not touched upon the eligibility criteria. Please understand.
I follow, please.
That is why we are again and again requesting you. Now, if you find it is difficult, you are not able to convince your government, we will proceed to hear the matter and pass orders.
My lords, if there are more merited candidates who want to get appointed, it's in the state's interest to have more merited candidates appointed, regardless of where they have written exam. Unfortunately, what has happened in our case is the primary school teachers, the Tondra Agirat Swami. District-wise issue the notification, we are also, our hands are tied.
Adre, The question is, why did you make such changes which has affected the rights of certain applicants? And even in the second circular, you rightly said, no, it will not be made applicable to all the processes that have commenced. That again you changed by making another circular. How could you make that applicable to the process that have already commenced?
Commencement
Otherwise,
ಅಂದ್ರೆ ಬರೀ provisional list prepare
please
ಆಗಿತ್ತು.
understand, they are
Final-
saying they
final
are
select
already
list ಆಗಿರ್ಲಿಲ್ಲ.
in the select list.
ಇಲ್ಲ
Now,
select
because
list
of
ಆಗಿಲ್ಲ.
this select
ಆಗಿರ್ಲಿಲ್ಲ ಸ್ವಾಮಿ. ಅಲ್ಲ select list ಆಗಿರ್ಲಿಲ್ಲ. ಇಲ್ಲ provisional list ಗೂ select list ಗೂ ವ್ಯತ್ಯಾಸ ಇದೆ. Select list, what is select list is a final list. Final list prepare ಆಗಿಲ್ಲ, ಇವತ್ತಿಗೂ ಆಗಿಲ್ಲ.
Your lordship may kindly see.
It is up to you. It is up to you. We have
Please.
expressed our
Please, I bow to my
prima
lord.
facie opinion.
I bow to
You
my
want
lord.
to argue the matter, you are free to argue the matter, we will consider. No
I
difficulty.
bow to my lords, my lord. I may be given another opportunity, my lords, because even the state is interested. Though I'm not authorized to make the submission, the state wants the best of the candidates as teachers, my lords. But this one difficulty is there. I will again seek instructions, please. It may be taken up in any time in the week or week after that.
Your lordship may kindly see, ಈ judgment ನಲ್ಲಿ conclusion ನಲ್ಲಿ conclusion para 42 ಅದರಲ್ಲಿ 2 audible ಮಲ್ಲ conclusion ನಲ್ಲಿ 42 ಅದರಲ್ಲಿ 2
ಅದೇ
eligibility criteria for being placed in the select list notified at the commencement of recruitment process cannot be changed midway through recruitment process unless extant rules so permit or the advertisement which is not contrary to extant rules so permit. Even if such change is permissible under the extant rules or the advertisement, the change would have to meet the requirement of Article 14. New 371J ಗೆ ನಾವು
that is what I was pointing out.
ಕಾಯ್ದೆ ಪ್ರಕಾರ ಅದು ತಪ್ಪಾಗಿತ್ತು ನಾವೀಗ
No, first of all, the learned AG is not trying to make an attempt to show
I understand
that there is such a provision. He has not made any such submission. He is not able to point out to any such provision.
Please.
So, in what all that he is trying to say is, no, we have not done anything in respect of eligibility criteria. That is all he is trying to say. And we have expressed that that cannot be a narrow view of that word. Anything that touches upon the eligibility of the candidate to be selected would fall within the term eligibility criteria. Even if you are able to point out that there is a provision in the rules to make changes, the rider is Supreme Court says, no, it should not go against Article 14. There are 2 threshold bars that you'll have to pass. Otherwise, it is difficult.
A para 5 will Swami, 1 ನಿಮಿಷ Swami, a judgmental para 5. On the merits, sir. Please.
Merits of the matter.
Please.
You want to argue the matter, we will hear it completely, no difficulty. But prima facie, this is what we see. And they have clearly made out a case. Initially, ನೀವು ಏನ್ ಸರ್ಕ್ಯುಲರ್ ಪ್ರಕಾರ ನೀವು process start ಮಾಡಿದ್ರಿ, ಅದನ್ನೇ maintain ಮಾಡಿದ್ರೆ, they would not have any difficulty.
But then that would have been against the judgments of the Honorable Supreme Court, Constitution bench judgments. That is the difficulty, my lords. Because we cannot restrict a candidate merely because he's in reserved category, comes from a reserved category, to restrict him to that list alone.
Who asked you to make that changes?
By oversight, we were duty bound to correct it.
Could have simply said, no, we have already commenced the process, and therefore, even if there is any changes that are to be brought, it can be brought only subsequently. We cannot make it
changes ಮಾಡದೇ ಇದ್ರೆ ನಾವು
process that
changes
have already come.
ಮಾಡ್ದಿದ್ರೆ my
ಅಷ್ಟೇ
lord,
ಹೇಳಿ ನೀವು
like-
ನಿಲ್ಲಿಸ್ಬಿಟ್ರೆ ಸಾಕಾಗಿರೋದು. Your second circular was correct.
ಅಲ್ಲ ನಾವು ಚೇಂಜಸ್ ಮಾಡದೇ ಇದ್ರೆ again the matter would have come before my lords and entire recruitment
ಆಯ್ತು.
process would have been struck down.
You should have made this submission before the court. Who asked you to take a unilateral decision? Avaga you could have put it on the orders of the court. See, in terms of the orders, we are constrained to do it, so we have done anta. There was no such requirement. We'll have it on 19th.
19th ಬೇಡ ಸ್ವಾಮಿ, ನಾಳೆ ಒಂದೇ ದಿನ ವರ್ಕಿಂಗ್ ಡೇ ಇರೋದು. ಶಾರ್ಟ್ ಅಕೌಂಟ್ so that my lords have.
See, I don't think you'll be permitted to make this submission. I don't think you'll be able to make that submission. You please go on with the matter.
But then my lords, their case is that it's different from the cases which are listed in Bangalore. Bangalore, same matters are being heard on the same issue then. On 371J, with regard to the change of the circulars, the circular change ಆಗಿರೋದ್ರಿಂದ affects their rights of prejudice ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಇಲ್ಲಿ the same cases ಇರೋದು. Because they said they're not arguing that, they're not challenging that, they wanted to find out if it was possible for them to be accommodated in other districts, we are making an effort. Not that we want to avoid arguing the matter, my lords. We are, because it's being argued in Bangalore also, not that we are avoiding. The same list of authorities, I'm placing it before my lords also.
ಅಲ್ಲಿ comments ಆಗಿದೆಯಾ arguments?
Comments ಆಗಿದೆ. In fact, the petitioners themselves are assisting the court here.
ಹೌದಾ Mr. Jaykumar, have you started arguments there?
ಇಲ್ಲ ನಮ್ಮ ಯಾವುದು ಮ್ಯಾಟರ್ ಬಂದಿಲ್ಲ, ಬಟ್ ಐ ಆಮ್ ಟೋಲ್ಡ್ ಟೀಚರ್ಸ್ ಒಂದು ಪೆಟಿಷನ್ ಇದೆ ಅಂತೆ, ಗುಲ್ಬರ್ಗಾ ಏರಿಯಾದ್ದು ಒಂದು ಪೆಟಿಷನ್ ಇದೆ ಅಂತ ಹೇಳಿದ್ರು. ಅದರದ್ದು ಆರ್ಗ್ಯುಮೆಂಟ್ ಇಲ್ಲಿವರೆಗೇನು ಶುರುವಾದಂಗೆ ಕಾಣೋದಿಲ್ಲ. ನಾನು ಇಲ್ಲ ಅದ್ರೊಳಗೆ, ಬಟ್ ಐ ವಿಲ್ ವೆರಿಫೈ. I will also verify.
Posted on 21, my lord. 21 ಕೇಂದ್ರ ಇದೆ, senior counsel argue ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಮ್ಯಾಟರ್ ಚಂದ್ರಶೇಖರ್.
You are appearing for the including.
Yes, ma'am. Yes, please. Yes.
ಅಲ್ಲಿ
Your candidates for
Yes, from
371J, na?
yes, my lord. Yes, yes.
You are opposing these petitioners.
Yes, my lord.
You want to
They are
oppose these
candidates
petitioners?
from.
Yes, my lord. I am respondent number, that is proposed respondent number 8 to 12, my lord. Permitted to include.
ಈಗ ಸೆಲೆಕ್ಟ್ ಲಿಸ್ಟ್ ಆಗೋಗಿದೆ, ಅನೌನ್ಸ್ ಮಾಡಿದಾರಾ?
during the pendency before the KSAT, there was an interim order. And before that only, before issuing any right accrued to the candidates who are selected, there was an interim order throughout the proceedings. And they did not filed any application before the KSAT. And now also they are filing it.
My learned friend, it appears, may not be aware, my lords, I have appeared before the tribunal. Both sides were represented. In fact, learned senior counsel Sri Jaykumar Patil appeared for one set of students in the associate professor's case and also in the GPSTR case in Bangalore.
No. Let us not go into other aspects of the matter not connected with this process.
This is the only process. This is the same notifications which are under challenge.
ಯಾವುದು ಟೀಚರ್ಸ್ ತಾನೇ ಇದು?
Teachers there. Teachers, associate professors,
ಇಲ್ಲ ಅಸೋಸಿಯೇಟ್ ಪ್ರೊಫೆಸರ್ಸ್ ಬೇರೆ ಆಗುತ್ತೆ. ದಟ್ಸ್ ಎ ಸ್ಟೇಟ್ ವೈಡ್ ಸೆಲೆಕ್ಷನ್.
Correct. Same issue ಅಂತ ಹೇಳ್ಬಿಟ್ಟು they're being heard together.
We are concerned only with the teachers now.
My lords, I would consider it my good fortune to argue before my lords and to take an order before my lords. But I also have a duty to place it before my lords that one such case, at least a few of such cases are being heard before the principal bench. Despite that, if the matter can be heard here, I would be very happy to assist.
In respect of teachers,
How the Swami? Because see what has happened, my lords, with regard to recruitments. One was with regard to KPCL, one was with regard to associate professors, one was with regard to primary school teachers. In all the cases, the notifications were one and the same, issued at the same time almost. And in all the cases, they had to issue this addendum, which my lords have again taken exception to. So the question before the court in all the cases same.
No. Don't say that it arises out of the same notification. Adalla. We are asking you specifically, is it regarding teachers?
Yes, with regard to teachers, yes. Primary school teachers There is one set of cases, there is one batch of cases relating to associate professors.
Ali.
Anyway, please give that information to the learned senior counsel.
Please,
Let
please.
him also see.
Please.
We will have it on 20th then. 19th, but on 20th will.
My lord, with regard to the other aspect, I may need not pursue, my lords.
Huh?
With regard to the other aspect, whether they could be accommodated elsewhere or not, that need not be pursued any further.
My
My lords, I bow to my lords. My lords, my lords' sense of equity, I am grateful. I am bow to my lords, but I have done my best so far, my lords. I can pursue again.
That is why we are saying, if there is some genuine difficulty, let us go on with the matter on the merits.
Please,
let us
please.
not try to persuade the government. ಅವ್ರಿಗೆ ಇಷ್ಟ ಇಲ್ಲ ಅಂತ ನಾವು ಫೋರ್ಸ್ ಮಾಡಿ ಮಾಡೋದಂಗಾಗುತ್ತೆ ಬೇಡ.
ಇನ್ನೊಂದು ವಾರ ಟೈಮ್ ಕೊಟ್ಟು ನೋಡಿ ಸ್ವಾಮಿ, ಪ್ಲೀಸ್. ಐ ವುಡ್ ಓನ್ಲಿ ಮೈ ಹಂಬಲ್ ರಿಕ್ವೆಸ್ಟ್. ಆಗದೆ ಇದ್ರೆ ನೀವು ಎನಿವೇ ವೇರ್ ಇನ್ ಮೈ ಲಾರ್ಡ್ಸ್ ಹ್ಯಾಂಡ್ಸ್ ಇಟ್ ಕ್ಯಾನ್ ಬಿ ಹರ್ಡ್ ಆನ್ ಮೆರಿಟ್ಸ್ ಅಂಡ್ ಬಿ ಡಿಸ್ಪೋಸ್ಡ್ ಆಫ್.
ಆಯ್ತು, ಇಂಪ್ಲೀಡಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ಸ್ ಅಲೋ ಮಾಡೋಣ.
I do not know who those applicants are.
Including application.
They say they would be affected if any
Please,
adverse
please.
orders are passed.
Please,
Andre, they
I
are
have
all
no
the
objection.
371J candidates.
Please, I have no objection. I have no.
ಅಲ್ಲ ಇವರು ನಮ್ಮ ಜಯಕುಮಾರ್ ಪಾಟೀಲ್ ಅವರು.
ಇಲ್ಲ, ನಾನು ಅದನ್ನ ಅವ್ರದ್ದು ಇಂಪ್ಲೀಡಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಇಂದು ನೋಡಿಲ್ಲ, ನಾನು ನೋಡ್ತೀನಿ. ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಗೆ
ಈ ಕಾಪಿ ಕೊಟ್ಟಾರಿ, ಜಸ್ಟ್
ಅವ್ರನ್ನ
ಕೊಟ್ಟಾರಿ.
ಹಿಯರ್ ಮಾಡೋದಕ್ಕೆ
ಕೊಟ್ಟಿದ್ದಾರೆ.
ನಮ್ದೇನು ಅಬ್ಜೆಕ್ಷನ್ ಇಲ್ಲ. ಟು
Scan
ಮೇಕ್
ಮಾಡಿ
ದಿ
ಕಳಿಸ್ತೀನಿ.
ಕಾಪಿ ಇಟ್ಸ್ ಡಿಫರೆಂಟ್.
We'll consider. Once again, at the request of the learned AAG, the matter stands adjourned to 25th of November. Please come on 25th of November.
Please.
Please. My lords, I have placed a list of authorities, my lords, that may be taken on record, my lords, please.
ಅಲ್ಲ ಇವಾಗ ಬೇಡ ಅದು.
Madam, please, I'll place it on 25th. Please, please. Much obliged, much obliged. Obliged.
Serial number 10, BK Iraman.
Serial number 10, my lord, office raised the objection, my lord. Now, copy of the statement of objection is not served on. We served the
received,
copy to the other side.
Huh?
I have received on Friday, madam.
Learned counsel for the petitioner submits that he has received copy of the statement of objections filed at the hands of the respondents. Yes. Release this matter.
Ready,
On,
ready was.
21st.
ಇಲ್ಲ ready ಇದೀನಿ sir.
Huh?
Ready for it. Detention order ಇದೆ sir.
For interim prayer.
ಇಲ್ಲ ಇಂಟೀರಿಯಂ ಪ್ರೇಯರ್ ಕೊಟ್ಟರು ಸರ್.
ಏನಿದೆ? What is that?
Gunda Act, my lord.
ಗುಂಡಾ ಕೆಳಗೆ ಹಾಕಿದ್ದಾರೆ.
Age was appearance.
ಗುಂಡಾ ಕೆಳಗೆ ಹಾಕಿದ್ದಾರೆ ಸರ್.
ಏನ?
ಗುಂಡಾ
Act, my lord. Detention order is challenged.
Detention order.
Detention order.
ಕೊಡಿ.
Original records is required, my lord. That's
I have produced the entire judgments of the trial court, madam. Totally he involved in 8 cases. Out of 8 cases.
Detention order.
Detention order.
Gunda Act.
Huh?
Gunda Act.
Detention order.
Detention order.
We have held that writ petition before division bench is not maintainable. This is to be listed before learned single judge.
Correct, my lord. First I have filed single petition, my lord. Office has raised objection.
ಏನಂತ ಮಾಡಿ?
Filing count ಅಲ್ಲಿ raise objection ಮಾಡ್ರು. It comes to division bench, my lord.
Why?
Scrutiny.
Please see our order, sir.
Scrutiny.
Division bench has passed an order.
Sir, ನಿಮ್ first page ಹಾಕಿ.
This is not writ petition habeas corpus.
Correct, my lord. I have.
This is not a writ petition habeas corpus.
Correct, my lord. I have filed only single judge filed.
Correct.
Subsequently, filing counter has also taken my application.
Correct.
Thereafter, they have told that you should file second set.
Why?
Office has a circular ಇದೆ sir.
Torsi. Please show, sir. See, why do you want to accept whatever the office says? We have passed an order and you have rightly not mentioned this as a writ petition habeas corpus. Then how is it placed before the division bench? You should be able to convince, sir.
No, I have told to the scrutiny, sir, it is for detention order.
ಕೇಳಿ ಯಾವ ಸರ್ಕ್ಯುಲರ್ ಅಂತ ಕೇಳಿ. Please don't accept whatever they say. ಯಾವ್ದ್ರಿ ಅದು ನಮ್ದು ಆರ್ಡರ್? Percolate. That will not come up for consideration. What can be called in question is only the detention order. That is only a process. Otherly, it will go before a committee of 3 judges. But the order is the writ petition is a challenge to the detention order passed by the. ನಾನು ಇದ್ದೆ ಅದರಲ್ಲಿ ಈ ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡಿದಾಗ ನಾನು ಇದ್ದೆ ಕಮಿಟಿಗೆ. That will not come up for question anywhere. What can be questioned is only the detention order. There is the circular which says not only habeas corpus petitions, any order of detention which is based on opinion furnished by the advisory board constituted under the provisions of the Gunda Act shall be placed before the division bench. All right. Really?
Lord, one submission, my lord. We'll get the records, my lord, of the advisory board. Lords of have it any next week, my lord, any
Lord,
date may be fixed, my lord. We'll get that,
The
all
respondent
the
themselves,
documents, my lord.
themselves contended that the petitioner is involving 8 cases, my lord.
Huh?
8 cases. Out of 8 cases, 5 cases were acquitted, my lord. Only remaining 3 cases. And last 2 cases are posted for evidence and cross-examination. He is also completed, only for argument. He is under judicial custody since from arrest, my lord.
Sri, ಆಯ್ತು. What are you asking? Interim prayer.
Interior prayer, my lord.
For what? ಏನಂತ?
That order
Pending disposal of the writ petition, please to stay the execution. ಬರೋದಿಲ್ಲ. It is as good as main prayer.
Yes, yes.
At the request of the learned government advocate, release this matter on 19th of November.
Yes.
19th, ತುಂಬಾ ಕೇಸ್ ಇದೆ ಸರ್ ನಾವು.
Huh?
19th ತುಂಬಾ ಕೇಸ್ ಇದೆ.
These are all.
ಅಲ್ಲ 20th
ಆಯ್ತು 20th.
Hearing on CL number 11, Ganesh Subhash Chandra Kalaburagi.
Lordships, we have filed application seeking withdrawal of appeal, your lordships. We have settled the dispute. I have filed application along with affidavit of the appellant.
Huh?
I have filed, your lordships, application along with the affidavit of the appellant seeking permission to withdraw the suit, your lordships.
Learned counsel for the appellant has filed. The appellant has filed an application. Idu order on has filed an application in IA number 1 of 2024 under order 23 rule 1 of CPC seeking leave of this court to permit the appellant herein to withdraw the present appeal and consequently dismiss the suit filed by the appellant herein as withdrawn in OS number 26 of 2019 on the file of the senior civil judge and JMFC, Sindigi. Stop. Next para. Learned counsel submits that in the affidavit filed along with the application, it is stated that the respondents have refunded the entire earnest money of rupees 40 lakhs. And therefore, further prosecution of the present appeal is not warranted. Full stop. The parties have amicably settled the matter. And therefore, the appellant has filed this application seeking leave of this court to withdraw the appeal as well as the suit. Full stop. Next paragraph. Accordingly, the RFA is dismissed as withdrawn, and consequently, the suit filed by the appellant herein in OS number 26 of 2019 is also dismissed as withdrawn.
Your Lordship, court fees deposited. We have deposited the court fees, Your Lordship.
Illi,
ಯಾವ್ದು?
next para. Office is directed to return the court fee to the appellant in accordance with law. All other interlocutory applications pending are also disposed of accordingly.
Serial number 12, Preeti Patil Melkundi.
To appear for the respondents. Lords, 12.1 is not connected to
That is not
a division bench.
Maybe disconnected.
Huh?
It's not
12.1, Lords, is not connected to the first appeal. Connected appeal number is 202003.
One more MFA is there.
One more MFA there,
ಯಾವ್ದು?
202003, Swami,
List
of 24.
MFA
Lords,
02003 of 2024
24.
along with this matter.
Yes, Lords, I have filed application seeking permission to withdraw the amount in deposit by the appellant insurance company. Only, Lords, they are 50% amount they have deposited, contributory negligence ಅಂತ ಹೇಳ್ತಾರೆ. Lords, I may be permitted to withdraw the amount in. I have.
Just correct.
Our deposit, they are not disputing the accident.
Huh?
They are not disputing.
Saying contributory negligence.
Only contributory negligence, 50%. I have the deposition for my lordship's perusal.
ಇದರಲ್ಲಿ 50% you have deposited.
ಹೌದು, ಇದರಲ್ಲಿ
Will permit them to withdraw 50% out of that.
Yes.
ಆಗ್ಬೋದಾ? ಯಾವ್ದದು?
ಫಸ್ಟ್ ಅಪೀಲ್.
MFA 204200 of 2023 ಅಲ್ಲಿ order on IA number 1 of 2024.
Yes.
This application is filed by the respondent claimants.
Yes.
Seeking leave of this court to withdraw the amount deposited by the appellant insurance company.
Yes.
Full stop. Learned counsel for the appellant insurance company submits that in the appeal, the insurance company, appellant insurance company has raised question of contributory negligence. And therefore, the amount should not be refunded at this juncture. Stop. However, learned counsel for the respondent claimant submits that even if this court were to hold that there is contributory negligence on the part of the other vehicle, even then, it would not absolve the appellant insurance company from payment completely. Stop. Next para. We therefore permit the claimants to withdraw 50% of the award amount already deposited by the insurance company. Stop. Accordingly, IA number 1 of 2024 is disposed of.
12.1
It may be
not connected.
D-link.
D-link MFA 200203 of 2024 from this matter and connect 202003. ಅದು ತಪ್ಪಾಗಿದೆ ಅಂತ ಕಾಣಿಸ್ತಾ ಅಷ್ಟೇ.
ಅದೇ ನಂಬರ್ ಹಿಂದೆ ಮುಂದೆ ಆಗಿದೆ.
Of 2024 along with this matter. Yes.
Serial number 13. Shivashankar H. Manu.
Appear for the respondent number 1 and 2, my lord.
Huh?
Lordship
That what
is
is matter.
directed me to get the instruction, my lord. Why the separate notice is subsequent notification is issued.
Ah,
It is same, my lord, Anganwadi Kendra. But kindly see, my lord, page number 25, my lord. That is guidelines issued by the, my lord, government. Regarding the, my lord, ಆಯ್ಕೆಯ ಆದ್ಯತೆ. Lordship get it, page number 25, my lord.
ಅನಕ್ಷರ ಏನು?
Or that is annexure, my lord.
ನೀವ್ ಹಾಕಿದ್ದೀರಾ?
ಅವ್ರು ಹಾಕಿ ರಿಟ್ ಪಿಟಿಷನ್ದಲ್ಲಿ ಹಾಕಿ ಅನ್ನಕ್ಷರ್ ಬಿ my lord. Notification.
ಅಧಿಸೂಚನೆ
ಅಧಿಸೂಚನೆ.
2/2022.
Yes, ma'am.
ಹಾ,
Typed copy, my lord, that is 25. Page number 25, my lord. ಆಯ್ಕೆಯ ಆದ್ಯತೆ. ಅಂಗನವಾಡಿ ಕಾರ್ಯಕರ್ತ ಮತ್ತು ಸಹಾಯಕ ಹುದ್ದೆಗಳಿಗೆ ಈ ಕೆಳಕಂಡಂತೆ ಆದ್ಯತೆ
Page
ಪಡೆಯಲು
38, my lords.
38.
38 page.
ಪೇಜ್ ನಂಬರ್ ಬೇರೆ.
ಮತ್ತೊಂದು ಕೊಟ್ಟಿನಿ ಸರ್. Page 38,
ಹಾ,
sixth point.
ಸಿಕ್ಸ್ತ್
ಹಾ,
ಆಯ್ಕೆಯ ಆದ್ಯತೆ. ಅಂಗನವಾಡಿ ಕಾರ್ಯಕರ್ತ ಮತ್ತು ಸಹಾಯಕ ಹುದ್ದೆಗಳಿಗೆ ಈ ಕೆಳಕಂಡ ಆದ್ಯತೆ ಪಡೆಯಲು ಇಚ್ಛಿಸುವ ಅರ್ಜಿದಾರರು ನಿಗದಿತ ವಿದ್ಯಾರ್ಹತೆ ಹೊಂದಿದ್ದು ವಯೋಮಿತಿಯೊಳಗೆ ನಿಗದಿತ ಮೀಸಲಾತಿ ಮತ್ತು ಸ್ಥಳೀಯರಾಗಿರಬೇಕು. ನೆಕ್ಸ್ಟ್ my lord, I will come to my lord 2. ಇಲಾಖೆಯ ಸಂಸ್ಥೆಯ ನಿವಾಸಿಗಳ ಆಯ್ಕೆ. ಅಂಗನವಾಡಿ ಕಾರ್ಯಕರ್ತೆ ಮತ್ತು ಸಹಾಯಕಿ ಹುದ್ದೆಗಳಿಗೆ ಬಾಲ ನ್ಯಾಯ kindly say this is important. ಬಾಲ್ಯ ನ್ಯಾಯ ಕಾಯ್ದೆಯಡಿ ಇಲಾಖೆಯ ಸಂಸ್ಥೆಗಳಲ್ಲಿ ಹಾಗೂ ರಾಜ್ಯ ಮಹಿಳಾ ನಿಲಯಗಳಿಗೆ ಆಶ್ರಯ ಪಡೆದ ಹಾಲಿ ಮಾಜಿ ನಿವೇಶನಗಳು ಅರ್ಜಿ ಸಲ್ಲಿಸಿದಲ್ಲಿ ಆಯ್ಕೆಯ ಆದ್ಯತೆಯ ಕ್ರಮ ಸಂಖ್ಯೆ 1 ನೇವರನ್ನು ಹೊರತುಪಡಿಸಿ ಇಫ್ ಇಟ್ ಇಸ್ ಮಲ್ ಸೆಲೆಕ್ಟೆಡ್ ದಿ ಮರ್ಡರ್ ದೆನ್ ಇವನು ಹೊರತುಪಡಿಸಿ ಇತರ ಎಲ್ಲ ಅರ್ಜಿಗಳನ್ನು ಸ್ವೀಕೃತ ಅರ್ಜಿಗಳನ್ನು ಪರಿಗಣಿಸದ ಎರಡನೇ ಆದ್ಯತೆ ಮೇರೆಗೆ ನೇರವಾಗಿ ಅವರು ಆಯ್ಕೆ ಮಾಡಲಾಗುವುದು. ಇನ್ ದಿಸ್ ಕೇಸ್ my lord,
ಅದಲ್ಲ. It is not about the selection already made. ಅದಲ್ಲ.
that's
ಅವ್ರು ಹೇಳ್ತಾ ಇರೋದು that post was reserved for scheduled caste candidate.
that's why my lord, that's why that is even that is reserved also my lord, that can be overlooked by this provision. ಎಲ್ಲ
ಒಂದನೆಯವರನ್ನು ಹೊರತುಪಡಿಸಿ.
ಹೌದು.
ಯಾವ ಕ್ರಮ ಸಂಖ್ಯೆ 1?
But Roman 1 my lord for a moment. Even Roman 1 also.
ಆಸಿಡ್ ದಾಳಿಗಳು
ಆಸಿಡ್ ದಾಳಿಗಳು ಆಯ್ಕೆ ಆಸಿಡ್ ದಾಳಿಗೆ ತುತ್ತಾದ ಮಹಿಳೆಯರು ಅಂಗನವಾಡಿ ಕಾರ್ಯಕರ್ತರು ಸಹಾಯಕ ಹುದ್ದೆಗಳು ಅರ್ಜಿ ಸಲ್ಲಿಸಿದಲ್ಲಿ ಇತರ ಎಲ್ಲಿ ಅರ್ಜಿ ಸ್ವೀಕರ್ತಾರೆ.
ನೀವು ಆಸಿಡ್ ದಾಳಿಗೆ ಒಳಗಾದವರ?
ಅಲ್ಲ, ಇದು ವಿಡೋ ಇದ್ದಾರೆ.
ವಿಡೋ
ಅಲ್ಲ, ಅವ್ರು ವಿಡೋ ನಾವು ಸೆಲೆಕ್ಟ್ ಮಾಡಿದ್ದನ್ನ
ನಂಬರ್ 4.
ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 4 ಬಿಫೋರ್ ಲಾರ್ಡ್ಶಿಪ್ my lord ಈಸ್ ಅನಾಥಾಶ್ರಮದಲ್ಲಿ ಬೆಳೆದಂತ ಹುಡುಗಿ. ಆಫನ್ ಗರ್ಲ್.
ಅಲ್ಲ ರೀ,
The point is not whether she is SC or not. That is the
ಕ್ರಮ ಸಂಖ್ಯೆ 1. ಯಾವುದು ಕ್ರಮ ಸಂಖ್ಯೆ 1?
ಆಯ್ಕೆಯಾದಲ್ಲಿ ಸಪೋಸ್ ಇಫ್ ಇಟ್ ಈಸ್ ಸೆಲೆಕ್ಟೆಡ್ my lord ಬಿಫೋರ್ ಲಾರ್ಡ್ಶಿಪ್ ಅಪೆಲೆಂಟ್ ನಂಬರ್ 1.
ಯಾವ ಕ್ರಮ ಸಂಖ್ಯೆ 1?
the 6-1.
If the reference is only to acid.
ಹೌದು, ಅವ್ರು ಹೊರತುಪಡಿಸಿ ಸಪೋಸ್ my lord ಆಸಿಡ್.
ಅದಲ್ರಿ, ಅಕಸ್ಮಾತ್ ಏನಾದ್ರು ಆಸಿಡ್ ದಾಳಿಗೆ ಒಳಪಟ್ಟವ್ರು ಏನಾದ್ರು ಸೆಲೆಕ್ಟ್ ಆಗಿದ್ರೆ that can be overlooked ಅಂತ ಇದು ಹೇಳೋದು.
ಹೌದು.
This is not that candidate.
ಅಲ್ಲ, ಆಫನ್ ದಲ್ಲಿ ಸೆಕೆಂಡ್ ಒನ್
ಕ್ರಮ ಸಂಖ್ಯೆ 1ನೇ ಅವರನ್ನು ಹೊರತುಪಡಿಸಿ. ಇದು ಯಾವ್ದು ಕ್ರಮ ಸಂಖ್ಯೆ 1 ಅಂದ್ರೆ? ಅದನ್ನೇ ಹೇಳ್ತಾ ಇರೋದು.
First preference is given to the.
That can be overlooked.
ಸೆಕೆಂಡ್ ಒನ್ ಇಸ್ ಟು ದಿ ಬಟ್ ದಿಸ್ ಒನ್ my lord.
ಹೌದು, ಇವ್ರು ಆಸಿಡ್ ದಾಳಿಗೆ ಒಳಪಟ್ಟವ್ರು ಅಲ್ವಲ್ಲ?
ಅಲ್ಲ, ಅದಕ್ಕೆ ನಾವು ಇವ್ರನ್ನ ಸೆಲೆಕ್ಟ್ ಮಾಡಿದೀವಿ ಸರ್.
ಯಾರನ್ನ?
ನಾವು ರಿಸ್ಪಂಬರ್ 4.
The concession is only in respect of a person who has suffered acid attack.
ಹೌದು, ಇದರಲ್ಲಿ ಯಾರು ಇಲ್ಲ.
This person is not that.
ಅಲ್ಲ, ಯಾರು ಇಲ್ಲ ಸ್ವಾಮಿ. ಅದಕ್ಕೆ ನಾವು ಏನ್ ಮಾಡಿದ್ವಿ,
So this cannot be made applicable.
ಅಲ್ಲ ಸ್ವಾಮಿ, ಇದರಲ್ಲಿ ಸೆಲೆಕ್ಷನ್ my lord ವಾಟ್ ಸೆಕೆಂಡ್ ಕ್ಯಾಟಗರಿ ಇವ್ರು ಬರ್ತಿದ್ದಾರೆ. ರಿಸ್ಪಂಬರ್ 4 is coming under the second candidate. For that is a reason my lord we selected. First my lord we have to give the preference to the acid.
ಯಾರು?
ಈ ಆಸಿಡ್ ಗೆ ದಾಳಿಗೆ ಒಳಗಾದವ್ರಿಗೆ ಫಸ್ಟ್ ಪ್ರಿಫರೆನ್ಸ್ ಕೊಡ್ಬೇಕು. ಇದರಲ್ಲಿ ಯಾರು ಇಲ್ಲ.
ಕರೆಕ್ಟ್.
ಅದ್ ಬಿಟ್ಬಿಟ್ವಿ. ಸೆಕೆಂಡ್ ಆದ್ಯತೆಗಳನ್ನ ಇವ್ರಿಗೆ ಕೊಡ್ಬೇಕಂತ ಇದೆ, ಅನಾಥಾಶ್ರಮದಲ್ಲಿ ಬೆಳೆದಂತ ಮಹಿಳೆಯರಿಗೆ.
But this will not permit you to overlook the reservation, sir.
ದಟ್ ಈಸ್ ಆಲ್ಸೋ
ಎಲ್ಲಿದೆ?
ಎಲ್ಲಾರು
Please show.
ಬಿಟ್ಟು ಎಲ್ಲಾರನ್ನು ಇದು ಮಾಡಿ ಅಂತಾನೆ ಹೊರತುಪಡಿಸಿ ಅಂತಾನೆ ಹೇಳ್ತಾರೆ.
No, no, sorry.
ಹೊರತುಪಡಿಸಿ ಈ ಎಲ್ಲ ಅಂಶಗಳು
Among first one can be overlooked.
ಅದನ್ನ ಆಸಿಡ್ ಆಯ್ತು ಸ್ವಾಮಿ.
Doesn't give any leeway to you to ignore reservation.
ಅಲ್ಲ ಅವ್ರದ್ದು ಕ್ಯಾಸ್ಟ್
Reservation is a constitutional provision.
ಕರೆಕ್ಟ್ ಸ್ವಾಮಿ.
You
ಇವ್ರದ್ದು
cannot overlook
ಅಲ್ಲ
that.
ಇವ್ರ ಅನಾಥಾಶ್ರಮದಲ್ಲಿ ಬೆಳೆದಂತ ಯಾವ ಕ್ಯಾಸ್ಟ್ ಅಂತ ಗೊತ್ತಾಗಲ್ಲ.
ಆದ್ಯತೆಯಲ್ಲಿ first one na you can ignore. What is that first one?
ದಿಸ್ ಇಸ್ ಆಸಿಡ್ ದಲ್ಲಿ
ಮತ್ತೆ
ಕರೆಕ್ಟ್ ಸ್ವಾಮಿ. ಸೆಕೆಂಡ್ ಒನ್ ಅಲ್ಲ ಸೆಕೆಂಡ್ ಒನ್ ದಲ್ಲಿ ಇವರು ಈ ಬಿಲಾಂಗ್ಸ್ ಟು ದಿ ದಿಸ್ ನಂಬರ್ 4 is belongs to the scheduled caste ಅಂತಾನೆ ಇಲ್ಲ.
let us take it that ಆದ್ಯತೆಯಲ್ಲಿ she falls under the second category.
Yes,
ಆಯ್ತು.
yes.
ಆಮೇಲೆ next.
Now my lord, subsequent notification is issued, my lord, kindly see, my lord, that is there is a government circular.
The provision for reservation, sir.
ಅಲ್ಲ ರಿಸರ್ವೇಶನ್ ಅಲ್ಲ ಇವರು ಯಾವ ಕ್ಯಾಸ್ಟ್ ಅಂತಾನೆ ಗೊತ್ತಿಲ್ಲ ಇವ್ರಿಗೆ.
Sir.
ನಾವು ನಂಬರ್ 4 ಇತರ ಅಂತ ಬರಿತಿದೀವಿ ನಾವು. ಯಾರಂತಂದ್ರೆ ದೇ ಡೋಂಟ್ ನೋ which caste they belongs. Parents
ಹೌದು sir, I understand. But you cannot give away the provision of reservation because it's a constitutional mandate.
that's true, my lord. Here, my lord,
Ignore the other criterias.
ಇದರಲ್ಲಿ ಈ ಪರ್ಸನ್ we don't know, my lord, whether she belongs to the general merit or, my lord, ST or SC. We don't know anything. For that is the reason we appointed as a itare anta, caste ಅಲ್ಲಿ ಇತರೆ ಅಂತ ಬರ್ತೀವಿ. We don't know, my lord.
Sorry,
For that is the reason, my lord, we have to give the preference to these person. First is acid. Second one, these type of the.
Let us see the provision for reservation, sir.
Please.
Lord, page number 35, my lord, kind.
35.
Page number 35. ಅದ್ರಲ್ಲಿ 3 ಇದೆ, my lord, conditions 3.
ಹುದ್ದೆ ಮೀಸಲಾತಿ.
ಹುದ್ದೆ ಮೀಸಲಾತಿ. ಹುದ್ದೆ ಖಾಲಿ ಇರುವ
ಸ್ಥಳ
ಆ ಹುದ್ದೆ ಜನಸಂಖ್ಯೆ ಆಧಾರದಲ್ಲಿ ಯಾವ ವರ್ಗಕ್ಕೆ ಮೀಸಲಾಗಿದೆಯೋ ಆ ವರ್ಗಕ್ಕೆ ಒಳಪಡುವ ವರ್ಗಕ್ಕೆ ಅರ್ಜಿಗಳನ್ನು ಮಾತ್ರ ಆಯ್ಕೆ ಪರಿಗಣಿಸಲಾಗುವುದು.
Correct.
Then 4 million.
How will you overcome this one?
4ದಲ್ಲಿ if the SCs are more than 40% in particular area, only SC candidate to be appointed.
Yes.
The provision as per my learned friend Milord, what's seeing at page 38, ಆಯ್ಕೆ ಅರ್ಹತೆ. Suppose 4% are SC persons. Among 4%, who will be chosen? So better position 1, 2, 3, 4 categories.
There is no provision.
Yes.
To ignore the
among
reservation. The reservation.
Yes. Among the reservation, my lord, suppose more candidates, four candidates are there. Among 4 candidates, who are the better candidates?
There may be a person who suffered acid attack.
Among
there
the
may
same
be a
category.
person.
Yes, my lord. Page 38 nalide. Among the only particular category only, my lord, that person, not the other person. GM cannot be appointed.
Correct.
In their order, my lord, they have given order to the GM, my lord. That is incorrect, my lord. My lord, order is at page number 57, my lord. 57. ಅದರಲ್ಲಿ ಕಾಲಮ್ ನಲ್ಲಿ ಫಸ್ಟ್ ಉತ್ನಾಳ ಅಂತಿದೆ ಮೇಲೋಡ್. ಉತ್ನಾಳ ಅಂಗನವಾಡಿ ಕಾರ್ಯಕರ್ತೆ ಶ್ರೀಮತಿ ಮಂಜುಳಾ ಇಸ್ ದಿ 4th ರೆಸ್ಪಾಂಡೆಂಟ್ ಅಂಡ್ ಹರ್ ಜಾತಿ ಇತರೆ ಅಂತ ಇದೆ ಮೇಲೋಡ್, ಅದರ್ಸ್. ಸೊ ಅಲ್ಲ SC ಕ್ಯಾಂಡಿಡೇಟ್ ಮಾತ್ರ ತುಂಬಬೇಕು, ಗೊತ್ತಾಯ್ತು ಅಷ್ಟೇ. ದಟ್ ಇಸ್ ದ ಪಾಯಿಂಟ್. ಅವ್ರು ಎಂತಿದ್ದಾರೆ, ಆಸಿಡ್ ಇದ್ರೆ ಅದು ಇದ್ರೆ ಅಂತ ಟೈಮ್ ನಲ್ಲಿ ಇಗ್ನೋರ್ ಮಾಡಬಹುದು ಅಂತ ಹೇಳ್ತಿದ್ದಾರೆ.
Those are all other criterias, but you cannot. You will have to first make provision for the vertical reservation. Amongst the vertical reservation, you may get all these categories. In all categories, vertical reservation antandre general, reserved, OBC, all these are vertical reservation. Horizontal reservation, amongst all those categories, you may have physically handicapped, you may have a political sufferer, you may have ex-military. Adರಲ್ಲಿ in all the vertical category you may have all this. Similarly, in those categories you may also have person who has suffered acid attack.
Yes.
ಅದನ್ನ ಆದ್ಯತೆ ಕೊಟ್ಟಿದ್ದಾರೆ. ಯು ಮೇ ಹ್ಯಾವ್ ಎ ವಿಡೋ.
ಅದು ಇದೆ.
ಸೊ ಅದರಲ್ಲಿ ಯು ಹ್ಯಾವ್ ಟು ಗೋ ಬೈ ದಟ್ ಕ್ರೈಟೀರಿಯಾ. ನಿಯರ್ಲಿ ಬಿಕಾಸ್ ಇಟ್ ಸೇಸ್ ಅದಕ್ಕೆ ಅಲ್ಲಿ ಕ್ರಮ ಸಂಖ್ಯೆ 1 ಅಂತ ಮೆನ್ಷನ್ ಮಾಡಿರೋದು. That applies only to acid attack. You may ignore that one. You cannot give a go by to the reservation, sir.
Annexure H, my lord.
ಅಷ್ಟೇ ಇದ್ರೆ ಅವ್ರನ್ನ ಬೇಕಾದ್ರೂ ಅವ್ರನ್ನ
among the same category, my lord, not
Annexure H, my lord. ಉಲ್ಲೇಖ 1 ಪೇಜ್ ನಂಬರ್
57. Same. Next.
ಇದ್ರಲ್ಲಿ ಏನಾದ್ರು ರೀಸನ್ಸ್ ಕೊಟ್ಟಿದಾರಾ?
ಅದೇ ಇದು ಈ ಸರ್ಕಾರದ ಆದೇಶ 23/9/2017 ಪ್ರಕಾರ
ಓದಿ ಎಲ್ಲಿ ಕೊಡಿ. ಇದರಲ್ಲಿ ರೀಸನ್ಸ್
ಉಲ್ಲೇಖ 1
ಇಲ್ಲದಿದ್ರೆ ಸೆಪರೇಟ್ಲಿ ಇಫ್ ದೇರ್ ಇಸ್ ಎನಿ
ಅದೇ ದಿಸ್ ಇಸ್
ರೆಸಲ್ಯೂಷನ್ ಪಾಸ್ಟ್ ಯು ಮೇ ರೀಡ್.
ದಟ್ಸ್ ವೈ ಮೈ ಲಾರ್ಡ್ ಈ ಸರ್ಕಾರ ಆದೇಶದ ಅನ್ವಯ ಉಲ್ಲೇಖ 1 ಸರ್ಕಾರ ಆದೇಶದ ಅನ್ವಯ ವಿಜಯಪುರ್ ಸೋನ್ಸೋ ನಗರ ಯೋಜನೆಯಲ್ಲಿ 2021-22ನೇ ಸಾಲಿನಲ್ಲಿ ಖಾಲಿ ಇರುವ ಅಂಗನವಾಡಿ ಕಾರ್ಯಕರ್ತ ಸಹಾಯಕರ ಹುದ್ದೆಗಳ ಭರ್ತಿಗಾಗಿ ಉಲ್ಲೇಖ 2 ಅನ್ವಯ ಆನ್ಲೈನ್ ಮೂಲಕ ಅರ್ಜಿಯನ್ನು ಕರೆದು ಅಧಿಸೂಚನೆ ಹೊರಡಿಸಲಾಗಿತ್ತು. ಸದರಿ ಹುದ್ದೆಗೆ ಸ್ವೀಕೃತವಾದ ಅರ್ಜಿಗಳನ್ನು ಉಲ್ಲೇಖ 1 ಸರ್ಕಾರದ ಆದೇಶದನ್ವಯವೇ ವಿಧಿವೆ, ಅಂಗವಿಕಲೆ, ಪರಿತತ್ವೆ, ಪರಿಶಿಷ್ಟ ಜಾತಿ, ಪರಿಶಿಷ್ಟ ಪಂಗಡ ಹಾಗೂ ಸ್ಥಳೀಯ ರಹವಾಸಿ ಮಹಿಳೆ ವಿದ್ಯಾರ್ಥಿಯ ಮೆರಿಟ್ ಆಧಾರದ ಮೇಲೆ ಅಂಗನವಾಡಿ ಕಾರ್ಯಕರ್ತ ಸಹಾಯಕರ ಹುದ್ದೆಗೆ ಬಂದ ಅರ್ಜಿಗಳನ್ನು ಉಲ್ಲೇಖ 3 ಅನ್ವಯ ಪರಿಶೀಲಿಸಿ ನಂತರ ಉಲ್ಲೇಖ 4 ಅನ್ವಯ ಜಿಲ್ಲಾ ಆಯ್ಕೆ ಸಮಿತಿ ಚರ್ಚಿಸಿ ಹಾಗೂ ದಿನಾಂಕ 6/7/2022 ಜಿಲ್ಲಾ ಆಯ್ಕೆ ಸಮಿತಿ ಅನುಮೋದನೆ ಪಡೆದು ಸದರಿ ಆಯ್ಕೆ ನಡವಳಿಕೆ ಮೇರೆಗೆ ಉಲ್ಲೇಖ 5 ಅನ್ವಯ ಅಂತಿಮ ಆಯ್ಕೆ ಪಟ್ಟಿ ಹೊರಡಿಸಿ ಅರ್ಹ ದಾಖಲೆಗಳು ಲಗತ್ತಿಸಿ ಶಿಶು ಅಭಿವೃದ್ಧಿ ಯೋಜನಾಧಿಕಾರಿಗಳು ವಿಜಯಪುರ ನಗರ ಇವರು ಅಂಗನವಾಡಿ ಕಾರ್ಯಕರ್ತರ ಸಹಾಯಕರ ಮಾನ್ಯತೆ ನೀಡಲು ಕೋರಿ ಉಲ್ಲೇಖ 6 ಅನ್ವಯ ಪ್ರಸ್ತಾವನೆ ಸಲ್ಲಿಸಿದ್ದಾರೆ. ಸದರಿ ಪ್ರಸ್ತಾವನೆಯನ್ನು ಉಲ್ಲೇಖ 5 ಆಯ್ಕೆಯ ಸಮಿತಿ ಸಭೆ ನಡವಳಿ ಹಾಗೂ ಉಲ್ಲೇಖ 1 ಅನ್ವಯ ಸರ್ಕಾರದ ನಿರ್ದೇಶನಗಳು ಕೊಟ್ಟು ವಿಜಯಪುರ ನಗರದ ಯೋಜನೆ ಖಾಲಿ ಇರುವ 2 ಅಂಗನವಾಡಿ ಕೇಂದ್ರಗಳು ಆಯ್ಕೆಯಾದ ಅಭ್ಯರ್ಥಿಗಳು ಇತರ ಅಂಗನವಾಡಿ ಕಾರ್ಯಕರ್ತರು ಅಂತ ಮಾನ್ಯತೆ ನೀಡಿ ಈ ಕೆಳಗಿನಂತೆ ಆದೇಶ ಹೊರಡಿಸಿದೆ. ಪೀಠಿಕೆಯಲ್ಲಿ ವಿವರಿಸಿದಂತೆ ಉಲ್ಲೇಖ 1 ಅನ್ವಯ ಸರ್ಕಾರದ ನಿರ್ದೇಶನಗಳು ಕೊಟ್ಟು ಸ್ಥಳೀಯ ರಹವಾಸಿ ಮಹಿಳೆ SSLCಯಲ್ಲಿ ತೇರ್ಗಡೆ ಹೊಂದಿದ ವಿದ್ಯಾರ್ಥಿಯ ಮೆರಿಟ್ ಆಧಾರದ ಮೇಲೆ ಹಾಗೂ ವಿಧವೆ ಅಂಗವಿಕಲೆಯಾದಲ್ಲಿ ಆದ್ಯತೆ ನೀಡಿ ಈ ಕೆಳಕಂಡ ಗ್ರಾಮದ ಹೆಸರಿನ ಮುಂದೆ ಕಾಣಿಸಿದ ಹಾಗೂ ಜಿಲ್ಲಾ ಸಮಿತಿಯಿಂದ ಆಯ್ಕೆಯಾದ ಉಲ್ಲೇಖ 5 ಆಯ್ಕೆಯ ಸಮಿತಿ ಸಭಾ ನಡವಳಿಕೆಯನ್ನು ಆಯ್ಕೆಯಾದ ಕೆಳಕಂಡ ಅಭ್ಯರ್ಥಿಗಳಿಗೆ ಅಂಗನವಾಡಿ ಕಾರ್ಯಕರ್ತೆ ಅಂತ ಮಾಸಿಕ 10,000 ರೂಪಾಯಿಗಳ ಗೌರವಧನ ಆಧಾರದ ಮೇಲೆ ಈ ಕೆಳ ಷರತ್ತುಗಳಿಗೆ
If you have records with you, if it says, see the complete reasons are not found here.
that is overlooked
By the candidature of this person who is more meritorious is not taken into consideration. If you have a separate resolution, please read it out.
this is not
It doesn't say why the candidature of this person has been ignored.
May I submit, my lord, page 52.
Records is ನೋಡೋಣ.
Page 52 ದಲ್ಲಿ ಸೆಲೆಕ್ಷನ್ ಪ್ರಿಲಿಮಿನರಿ ಸೆಲೆಕ್ಷನ್ ದಲ್ಲಿ
ನಿಮ್ಮ ಹೆಸರು ತೋರಿಸಿದ್ರಾ?
ಇಲ್ಲ, ಅಲ್ಲಿ 4th ರೆಸ್ಪಾಂಡೆಂಟ್ SC ಅಂತ ತೋರಿಸಿದ್ದಾರೆ ಮಿಲಾಡ್. 52 ದಲ್ಲಿ ಮಿಲಾಡ್ ಅನೆಕ್ಷರ್ ದಲ್ಲಿ ಮಿಲಾಡ್ ಉತ್ನಾಳ್ ವಿಲೇಜ್ ಅಲ್ಲಿ ಮಂಜುಳಾ ಇದ್ದಲ್ಲಿ ಪರಿಶಿಷ್ಟ ಜಾತಿ ಅಂತ ತೋರಿಸಿದ್ದಾರೆ ಮಿಲಾಡ್ ಪ್ರಿಲಿಮಿನರಿ ಲಿಸ್ಟ್ ನಲ್ಲಿ.
This is
ಅಂದ್ರೆ
ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 4
ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 4 ಪ್ರಿಲಿಮಿನರಿ ಲಿಸ್ಟ್ ಅಲ್ಲಿ 50
that is wrong.
That is wrong. And 56 ನಲ್ಲಿ ಫೈನಲ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ SC ಅಂತ ತೋರಿಸಿದ್ದಾರೆ ಮಿಲಾಡ್. ಅದರಲ್ಲಿ ಕೂಡ 56 ಪೇಜ್ ನಂಬರ್ ಅನೆಕ್ಸರ್ G ಅದರಲ್ಲಿ ಪರಿಶಿಷ್ಟ ಜಾತಿ ಅಂತ ಬಂದಿದೆ. ಬಟ್ ಅಟ್ ದ ಟೈಮ್ ಆಫ್ ಫೈನಲ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಡಾಕ್ಯುಮೆಂಟೇಶನ್ ವೆರಿಫಿಕೇಶನ್ ಮಾಡಿದ್ರೆ C ಬಿಲಾಂಗ್ಸ್ ಟು ಮರಾಠ ಕ್ಯಾಟಗರಿ. ಆ ಮರಾಠ ನೋಡಿ ಏನ್ ಮಾಡಿದ್ದಾರೆ, GM ಆರ್ಡರ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ನಾವೇನೋ ಅವರು SC ಇದ್ದಾರೆ ಅಂತ ನಾವು ಸುಮ್ಕುತ್ತೇವೆ. ಫೈನಲ್ ಆರ್ಡರ್ ಇಶ್ಯೂ ಮಾಡಿದ ನಂತರ GM ಬಂದ್ರು. Now my lord, they realized that that particular post reserved for SC, they transferred to some other place, again made vacant, and in the notification SC post was called out. This is the situation, my lord.
Yes.
Again they are this is the government, my lord, again defending their appointment, my lord. They are saying that this is the category they are appointing. ಅದು 4 ಬೇರೆ ಬೇರೆ ದಲ್ಲಿ ನಾವು ಆದ್ಯತೆ ಕೊಟ್ಟಿದ್ದೇವೆ ಅಂತ. ಬಟ್ ಬೇರೆ ಪೋಸ್ಟಿಗೆ ಕೊಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ my lord. ಬೇರೆ ಕ್ಯಾಟಗರಿ ಅಪಾಯಿಂಟ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ.
ಕಾಲಮ್ in the Order of appointment at annexure H.
Yes, my lord. ಅದರಲ್ಲಿ
Jati is
ಅದ್ರಲ್ಲಿ-
shown as itare,
ಹಾ ಅದರಲ್ಲಿ GM
but
ಕೊಟ್ಟಿದ್ದಾರೆ.
in other two they have shown it as first jati.
Yes, my lord. ಅಲ್ಲಿ ಮ್ಯಾನೇಜ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ. ಆರ್ಡರ್ ಕೊಡ್ಬೇಕಾದ್ರೆ ಅವ್ರು ಕೇರ್ಫುಲ್ ಆಗಿ ಕೊಟ್ಟಿದ್ದಾರೆ. ಅದು ಕೊಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ my lord. ಆರ್ಡರ್ ರಾಂಗ್ ಇದೆ.
I'll get the, my lord, particulars, all the documents, my lord. Even proceeding statement, what, which is related that government order 2017, my lord. Even I also get that order and I'll make submission.
ಅಲ್ಲ ಅಲ್ಲಿ ರೆಕಾರ್ಡ್ಸ್ ಇದ್ರೆ if they have discussed why please
My lord,
Yeah.
ಅವ್ರ SLC ಸರ್ಟಿಫಿಕೇಟ್ my lord ಮರಾಠ ಅಂತಿದೆ.
ಸ್ವಲ್ಪ ಇರ್ಲಿ, let us see the resolution. If everything is in writing, let us see that. What are the consideration?
That is the, even proceedings also, my lord, that is referred that government order, my lord, dated 29/2017. That, government order, my lord,
ಅಲ್ಲಿ they should have passed a resolution giving all the reasons. Idre please show it,
this is the proceedings.
otherwise we'll proceed.
ಅಲ್ಲ, this is the proceedings, my lord.
ಕೊಡಿ, reasons ಇದೆಯಾ?
ಅದ ಗೌರ್ಮೆಂಟ್ ಆರ್ಡರ್ನೇ ರೆಫರ್ ಮಾಡ್ತಾರೆ. ಮೀಟಿಂಗ್ ಈಸ್ ಕಮಿಟೆಡ್.
So in the, which is the notification calling for applications?
My lord, annexure B, my lord. Type the copy at page number 33, my lord.
Annexure D.
B, my lord, B, page number 33, the notification calling for the applications. And in the page 34, my lord, Marga Suchi antide, my lord. Page 34, otherly 3 point, third point and fourth point are very clear, my lord. Point number 3 and 4, my lord. That page,
ಅಲ್ರಿ ಯಾವ್ಯಾವ ಇದಕ್ಕೆ ಕರೆದಿದ್ರಿ? Applications were called for which Anganwadi centers?
this is
That is, my
including
lord,
this
page
project
number
and others,
32,
my
my
lord.
lord.
Page
Page
number?
number 32. 32, my lord, that is ಕ್ರಮ ಸಂಖ್ಯೆ 7 ಪ್ಲೇಸ್ಗಳಿಗೆ ಕರೆದದ್ದು. Under this, my lord,
ಯಾವ್ದು?
ತಾಲೂಕು
The applications for called for which Anganwadi centers?
ಸೆಂಟರ್, ಅದೇ ಸೆಂಟರ್ಗಳು.
ಹೌದು.
ಅವ್ರ notification ಕೊಡಿ.
Lord,
You not produced, my lord, that.
this is notification, no, ಇದು ಆನ್ಲೈನ್ ಬಂದಿತ್ತು, my lord. ಯಾವ ಪೋಸ್ಟ್ ಇದೆ ಅಂತ ಆನ್ಲೈನ್ ನಲ್ಲಿ ಬಂದಿತ್ತು. ಅದು ರೈಟ್ ಹೊಡೆದಿದ್ದ ನಾಲ್ಕು ಲಾಸ್ಟ್ annexure B ಪ್ರಕಾರ ಇದು ಬಂದಿದ್ದು ಆನ್ಲೈನ್ ನಲ್ಲಿ.
ಹಾ, ಇದ್ರಲ್ಲೇನೆ
ಅದೇ SC ಅಂತ
it is
ಹೇಳಿದ್ರು.
shown as SC.
SC ಅಂತ ಇದೆ, my lord. ಅದ್ರಲ್ಲಿ ಕೂಡ
You have totally ignored this.
SC ಅಂತ ಹೇಳಿದ್ರಿ. serial number 12.
ಮತ್ತೆ nothing is said about that in the resolution.
13. For that is the reason, my lord, that circular, my lord, as the base of that circular, committee has taken the decision. Committee has
Sir, they
taken the
should have
decision.
discussed. Though this is reserved for scheduled caste category, we
Even though-
find so and so reasons. Yenu ilve illa, first of all. They have totally ignored. If there was such a consideration, we would have again tried to find out whether that discussion is correct or not. They have simply ignored this fact that the applications were called for SC category.
Now, my lords,
List ಪ್ರಕಾರ ಇದೆ correct ಇದು?
ಹೌದು, ಅದೇ correct.
Please show us the original records.
Now, once, permit to make submission, my lord, now subsequent notification is issued. Lordship, my lord, directed us to consider his application.
Huh?
Because he already, my lord, applied earlier notification, my lord. Subsequent notification, my learned friend is produced that notification, my lord, here. Now, again, we called, my lord, because that post is vacant. We transferred that lady to the another
Illegal
place.
cannot be
She worked,
confirmed.
my lord,
by
1 year,
this
my
court.
lord. Now, my lord, your lordship, my direct us to, my lord, will at least consider their honor also, my lord.
ನಿಮಗೆ ಬೇಕಂದಂಗಲ್ಲ ಅವ್ರಿಗೆ ಇಷ್ಟ
ಅಲ್ಲ,
ಯಾರು ಬೇಕೋ
ಅದಂತಲ್ಲ, that is, my lord,
ಹಂಗಲ್ಲ ಆಗೋದಿಲ್ಲ ಸರ್.
ಅಲ್ಲ, dishonorable court, my lord, direct, my lord, that definitely will consider. it.
ಅಲ್ಲಿ she should contest against other eligible candidates.
ಅಲ್ಲ,
ನೀವು ಅಪ್ಲಿಕೇಶನ್ಸ್ ಕರೆದಿರೋದೇನೆ ಫಾರ್ SC ಕ್ಯಾಟಗರಿ.
ಹೌದು, ಕರ್ದಿ. ಅಲ್ಲ, ಇದರಲ್ಲಿ ಇದು ಸೇಮ್ ಅದನ್ನ ಈ ಸಬ್ಸಿಕ್ವೆಂಟ್ ನೋಟಿಫಿಕೇಶನ್, my lord. ಅದನ್ನ ಸೇಮ್ ಅದೇ.
ಅಲ್ಲ, ಅವ್ರನ್ನ ಕನ್ಫರ್ಮ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ ಮೇಡಮ್.
ಬರಲ್ಲ.
ಯಾಕಂದ್ರೆ ನಂದು ಡೇಟು ಬಾರ್ ಆಗಿದೆ, ನಂದು ಅದರಲ್ಲೇ ಬರುತ್ತೆ ಮೇಡಮ್.
ಅಲ್ಲ,
ಐ ಆಮ್ ಎಲಿಜಿಬಲ್ ಮೇಡಮ್. ಇನ್ಸ್ಟೆಡ್ ಆಫ್ ಮೀ ಥರ್ಡ್ ಪರ್ಸನ್ ವಾಸ್ ಅಪಾಯಿಂಟೆಡ್.
dishonorable court,
ಏಜ್ ಬಾರ್ಡ್ ಆಗಿದೆ ಅವಾಗ ಕರೆಕ್ಟ್ ಇತ್ತು ಮೇಡಮ್.
ಅಲ್ಲ,
Moreover,
dishonorable
ಅದು
court
illegal
taken into
ಮಾಡಿದ order ನ
consideration this
confirm
one, my
ಮಾಡ್ಲಿಕ್ಕೆ
lord.
ಆಗಲ್ಲ ಮೇಡಮ್.
If dishonorable court taken into consideration earlier proceedings and also, my lord.
Correct.
At the time of that notification, she is eligible.
No, she is not eligible.
That first notification, my lord.
No, she is not eligible because the category is open only for SCs.
ಅಲ್ಲ, ಅವ್ರ ಪ್ರಕಾರ, ಅವ್ರ
ನಾವು
ಕ್ಯಾಂಡಿಡೇಟ್,
ಇದೇವೆ ಎಲಿಜಿಬಲ್, ನಮ್ದು ಇದೆ.
ಅವ್ರದ್ದು.
ಅವಾಗ ನಾವು ಇದ್ದೇವೆ eligible.
She was the eligible, my lord, as per your lordship, my lord, that is observation. Taking into consideration that, my lord, criteria, but direct the authorities to, my lord, to proceed this notification,
No,
subsequent notification.
ಹಂಗಲ್ಲ ಮಾಡಕ್
totally illegal ಮೇಡಮ್. That is first notification also illegal.
ಹಂಗ್ ಮಾಡಕ್ ಆಗೋದು.
Because, my lord, now,
You know what has happened? Because it was open only for scheduled castes, many of the general category candidates who had more marks than this lady may not have applied at all. So she has not contested against other eligible candidates. ಅವಾಗೇನು ಟೈಮ್ ಬಾರ್ ಆಗಿದ್ಯಾ? ಏನು ಇಲ್ವಲ್ಲ.
ಅಲ್ಲ, ಅವ್ರಿಗೇನು ಆಗಿದೆ.
ಏಜ್ ಬಾರ್ ಆಗಿದ್ಯಾ ಅವ್ರಿಗೆ?
ಅವ್ರಿಗೆ ಆಗಿದೆ.
ಇಲ್ಲ, ಮಾಡ್ಲಿ ಲೆಟರ್ ಕಂಟೆಸ್ಟ್.
ಅವ್ರಿಗೆ
ಲೆಟರ್ ಅಪ್ಲೈ ಇನ್ ಅದರ್ ಕ್ಯಾಟಗರಿ.
lordship, my lord, permit him to, my lord, to is the, my lord.
ಪಾಲ್ಮಂದಿರದಲ್ಲಿ ನಿವಾಸಿ ಮಕ್ಕಳಿಗೆ ಅವರ ಜಿಲ್ಲೆಯಲ್ಲಿ ಎಲ್ಲೇ
ಬರೋದಿಲ್ರಿ. ಆ ಕ್ಯಾಟಗರಿ ವಿಲ್ ಕಮ್ afterwards, but the primary consideration is for which category it is reserved. That will be the first criteria. Amongst them, ನಾನು ಆಗ್ಲೇ ಹೇಳಿದ್ನಲ್ಲ, ಪ್ರತಿ ಒಂದು ಕ್ಯಾಟಗರಿಯಲ್ಲಿ, ವರ್ಟಿಕಲ್ ಕ್ಯಾಟಗರಿಯಲ್ಲಿ, ವೆದರ್ ಇಟ್ ಇಸ್ ಜನರಲ್, SC, ST, ಬ್ಯಾಕ್ವರ್ಡ್ ಕ್ಲಾಸಸ್, ಎಲ್ಲಾದ್ರಲ್ಲೂ ಕೂಡ you will have all these candidates. You may have acid attack, institutional nivasi, then widow. All these categories you may have in every vertical category. ಅಲ್ಲಿ ನೋಡ್ಬೇಕು, ಸೆಕೆಂಡ್ ಅಲ್ಲಿ ನೋಡ್ಬೇಕು. Primarily you cannot ignore the reservation. The post is meant only for a scheduled caste candidate. ಅದನ್ನ ನೀವು ಇಗ್ನೋರ್ ಮಾಡಕ್ಕಾಗಲ್ಲ just by showing the criteria. Eligibility criteria comes second. Amongst the eligible candidates, these are the eligibility criteria. ಅದನ್ನ ನೋಡ್ಬೇಕು. ಆಮೇಲೆ you cannot ignore the basic requirement of Reservation. ಮಾಡಕ್ ಬರೋದಿಲ್ಲ.
Regarding reservation, my lord, selection of reservation, that article at origin is not applicable only on the basis of the population of that area. If it
Same,
exceed 40%, then yes, yes.
Correct. That is the basic requirement.
Reservation is not applicable to this Anganwadi
What do you mean?
election.
ಇವಾಗ ಇಷ್ಟೊತ್ತರೆಗೂ ಅವ್ರು ಓದಿದ್ರಲ್ಲ.
ಅಲ್ಲ, ಅವ್ರು ಹೇಳಿದ್ರು, ಅವ್ರು 40% population ಮೇಲೆ reservation ಕೊಡ್ತಾರೆ.
That is why, based on the population, it
Based
is
on population.
identified for a scheduled caste category.
Based
How
on
can
the
you ignore
population.
that one?
Based on population only, not applicable to all the, like generally that.
ಎಲ್ಲಾ ಕಡೆ it is the same. It is based on population only. Everywhere it is same.
In this case.
Even for the post of panchayats. Everywhere it is the same. It is based on population only.
ಸರ್ ಬಾಲ್ ಮಂದಿರದ ಮಕ್ಕಳಿಗೆ ಯಾವುದೇ ರೀತಿಯಿಂದ ಕಾಸ್ಟ್ ನೋಡಲ್ಲ ಸರ್, ನೇರವಾಗಿ ಅವ್ರನ್ನೇ ಆಯ್ಕೆ ಮಾಡಿ
ಇದೆಲ್ಲ ನೋಡಿ, please don't ignore the statutory provisions. ಹಂಗೆಲ್ಲ ಮಾಡಕ್ ಬರೋದಿಲ್ಲ. ನಿಮ್ ಇಷ್ಟ ಬಂದಂಗೆ ಇಲ್ಲ ಇಲ್ಲಿ ರಿಸರ್ವೇಶನ್ ಕೊಡೋದ್ ಬೇಡ ಅದೆಲ್ಲ ಹೇಳಕ್ ಬರಲ್ಲ ನೀವು. ಹಂಗೆಲ್ಲ ಮಾಡಕ್ ಬರೋದಿಲ್ಲ. You have no, you cannot exercise that power ignoring statutory provisions. Adu reservation is a constitutional mandate. That is why all these are implemented in the notification itself. ನಿಮ್ಮ resolution ಅಲ್ಲಿ why have you not stated all this? ಹೌದು, ಇದು SC ಕ್ಯಾಟಗರಿಗೆ ನಾವು ಅಪ್ಲಿಕೇಶನ್ ಕರೆದಿರೋದು, ಆದ್ರೆ ನಾವು ಇದನ್ನ ಯಾಕೆ ಗಣನೆಗೆ ತಗೋತಾ ಇಲ್ಲ, ಇದನ್ನೆಲ್ಲ why did you not discuss? Why did you not discuss? ಈ ಜನಗಳಿಗೆ ಏನು ಗೊತ್ತಾಗಲ್ಲ, ಏನ್ ಬೇಕಾದ್ರೂ ಬರೀಬಹುದು ಅಂತನಾ? Yes. Any submission you want to make?
I'm appearing for response number 4, my lord.
ಆದ್ಯತೆ will come. ಹೌದು.
Today only High Court Legal Service Committee has entered the matter in me too. Today only High Court Legal Service Committee has entered the matter to appear on behalf of response number 4. Only 2 weeks time may be granted, once I will make my submission.
ಆಗಲ್ಲ. The state is there to protect the interest. It is the state which has made the appointment.
I am the response number 4.
Perfect. The petitioner. Appellant. Serial number 13. The appellant. Is assailing the impugned order passed in writ petition number 202260 of 2022, dated 27th of September 2023. Full stop. Next para. The appellant was the writ petitioner who had questioned the final selection list dated nil at annexure G, whereby the fourth respondent was appointed as Anganwadi worker at Withdrawal of Hittanalli village. Vijaypura Taluk and district.
Yes.
Correct? Correct? Taluk and district. Full stop. Undisputed facts are that by notification dated 2/2/2022, applications were invited for the post of Anganwadi workers within Vijaypura district. Full stop. The appellant and many other candidates applied for the post of Anganwadi worker at Withdrawal. Full stop. The fourth respondent was selected in terms of order dated 12/7/2022. Full stop. It was contended at the hands of the appellant herein that in the provisional select list and the final select list, it was shown that the fourth respondent belongs to scheduled caste category. Full stop. However, in the final order dated 12/7/2022, the caste of the fourth respondent was shown as others. Full stop. It is contended by the appellant that applications were called for the category of Anganwadi worker at Withdrawal, which was a post reserved for scheduled caste category. Full stop. The online application along with the vacancy list has been furnished before this court. Full stop. It is also not disputed at the hands of the learned government advocate who has secured instructions at the hands of Yaridu?
Designation.
CDPO.
CDPO.
Child Development Officer.
Child Development Project Officer who is present in the court, that it is true that the applications were called for in terms of the vacancy list appended to the application form, which clearly shows that Withdrawal was reserved for scheduled caste category. Full stop. Yes. ಅದಕ್ಕೇನೆ ಸಿ ಇಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ ಆನ್ಲೈನ್ ಮುಖಾಂತರ ಮಾಡಿದ್ದಾರೆ ಕರೆಕ್ಟ್ ಇಲ್ಲಿ ನಾಟ್ ಎಲಿಜಿಬಲ್ ಟು ಅಪ್ಲೈ ಕರೆಕ್ಟ್ ಅದಕ್ಕೇನೆ ಇಲ್ಲಿ there is no clarity. ನೋಡಿ ಇಲ್ಲಿ ಒಟ್ಟು 65 ಅಪ್ಲಿಕೇಶನ್ಸ್ ರಿಸೀವ್ ಆಯ್ತು ಅಂತಂದ್ರೆ ಓನ್ಲಿ 6 were eligible ಅಂತಾರೆ, 59 were ineligible ಅಂತಾರೆ, but they have not said ಆನ್ಲೈನ್ ರಿಜೆಕ್ಟ್ ಹೌದು ರಿಜೆಕ್ಟ್ ಆಗಬೇಕಾಗಿದೆ ಇನ್ಫಾರ್ಮೇಶನ್. ಅದಕ್ಕೇನೆ ಇನಿಷಿಯಲಿ she has shown it as scheduled caste. That is why it was accepted as only 6 were eligible anta. We do not know why the other 59 were rejected. ಏನು ಹೇಳಿದೆ? Stop. The contention of the appellant therefore is that the fourth respondent was ineligible to apply for the post, since she did not belong to scheduled caste category. Full stop. Next para. We have perused the original records furnished at the hands of the learned government advocate. Full stop. We find from the resolution passed by the selection committee on 15/4, 13/4 idu 18/4 ಏನ್ರಿ ಡೇಟ್ ಅದು?
Proceedings. Resolution speaks. ನೋಡಿ ಹೇಳಂತ date.
18/4/2022 that 65 applications were received insofar as Utnal Anganwadi Center was concerned. Full stop. However, only 6 applications were found eligible, and therefore the committee considered the 6 applications, including the application of the appellant herein. Full stop. However, the committee proceeded on the basis of the other eligibility criteria found in the notification dated 2/2/2022. Full stop. The committee opined that since the fourth respondent is an orphan,
A widow.
No, fourth respondent is an
orphan,
Yes.
and she resided in
State Reform House.
huh?
State Reform House. Rajya Sudharana.
ನಿಲಯ ರಾಜ್ಯ
Bal.
Huh? ಇಂಗ್ಲಿಷ್ ಅಲ್ಲಿ ಏನ್ ಹೇಳ್ತಾರ್ರಿ?
certified schools.
Huh? Resided in the children's home established by the state, and she had obtained 69.44% in the 10th standard examination, which was highest amongst the 6 eligible candidates, the fourth respondent was selected. Full stop. However, as rightly pointed out by the learned counsel for the appellant, the committee has ignored the fact that the post was reserved for a scheduled caste candidate. Full stop. Admittedly, the fourth respondent does not belong to scheduled caste category, since the certificate, caste certificate produced by the fourth respondent shows that she belongs to Maratha community.
Caste
Caste
certificate
certificate
ಮಾಡಿಲ್ಲ.
Caste certificate ಸಿ obtained SC ಅಂತ ತಗೊಂಡಿದ್ದಾರೆ, but record ನಲ್ಲಿ other than SC ನೋಡಿ they found at the time of appointment she belongs to Maratha ನೋಡಿ.
Maratha community.
Hindu Maratha.
Hindu Maratha community, which does not belong to scheduled caste category. Full stop. Next para. Having heard the learned counsel for the appellant, the learned government advocate, the learned counsel for respondent number 4. You are appearing for whom?
Respond 3.
Child development.
Yes.
Yura. And the learned counsel for respondent number 3.
For respondent number 4.
ಅಲ್ಲ ನೋಟಿಸ್ ಹೋಗಿತ್ತು,
ಸರ್ವ್ ಆಗಿದೆ, ಲೀಗಲ್ ಸರ್ವಿಸ್ ಅಥಾರಿಟಿ.
ಅಲ್ಲಿ ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಸಪರೇಟ್ ಆಗಿ Learned Counsel Shri
Santosh H. Patil.
Santosh H. Patil has been entrusted with this matter to appear for respondent number 4, through the
High Court Legal Services.
High Court Legal Services Committee. Perused the appeal papers. Full stop. We find that the basic requirement of the applicants belonging to the scheduled caste category has been ignored by the committee. Full stop. Admittedly, the post of Anganwadi worker at Withdrawal was reserved for scheduled caste category. Full stop. The notification and the resolution dated 18/4/2022 also admits of this fact that the post of Anganwadi worker at Withdrawal was reserved for scheduled caste category. Full stop. No discussion is found in the resolution in respect of this aspect of the matter. Full stop. In our considered opinion, the
Please, widow. Yes, no, petitioner is the widow.
appellant is a widow.
Widow. Appellant is the widow.
The other eligibility criteria, other ಆಯ್ಕೆ ಆದ್ಯತೆ the other
Selection prayer.
eligible priority eligible alla the other
Eligibility criteria.
Priorities for selection.
alla priority other list of priority other order of priority as found in paragraph number 6 of the notification dated 2/2/2022 are required to be taken into consideration amongst the eligible candidates. Full stop. The basic requirement of the candidate to belong to scheduled caste category cannot be ignored. Full stop. Once a list is prepared and it is found that there are more than one eligible candidate from amongst the scheduled caste category, the other order of priority as found in paragraph number 6 can be applied. Full stop. That being the position, we find that the committee has totally ignored the basic requirement that the applicant should belong to scheduled caste category, since the post of Anganwadi worker at Withdrawal was reserved for a scheduled caste category candidate. Full stop. Next para. During the course of these proceedings, the learned counsel for the appellant had filed a memo along with a subsequent notification dated 9/10/2024, where again applications were called for the post of Anganwadi worker at Withdrawal, again showing the category as scheduled castes. Full stop. Is it a fact that she has been transferred elsewhere now?
Because, my lord, as per the government order, my lord, if she served 1 year, my lord, she is entitled for transfer.
Entitled for transfer.
Yes.
He left to the government. Whether they can continue.
What up, sir? Sala pala.
We were also appraised of the fact that the fourth respondent has now been transferred to
Jaipur city.
city, Vijayapura city, Anganwadi center. Full stop. Stay it before the learned single judge.
No.
I am not aware.
Huh?
I was not there, my lord.
You did not appear.
Yes.
But there is no stay for, that is the reason, my
honorable
lord, she continued, started working, but completed 1 year also, my lord, that is.
What happened, my lord, in the village, my lord, villagers gave the complaint to the particular SC candidate yaak tumbilla anta. Because of that, they are fulfilling their errors, my lord, they have transferred, my lord. But again, they made vacate. This was happened, my lord. All are colluding, my lord, here. Officers and persons, all are colluding here.
It was contended by the learned counsel for the appellant that having realized the grave error committed by the appointment committee in appointing the fourth respondent who was not eligible to be appointed at Withdrawal, the fourth respondent was later transferred to some other place, and now once again notification is issued calling for applications to fill up the post of Anganwadi worker at Withdrawal belonging to scheduled caste category. Full stop. At this juncture, learned government advocate and learned counsel for respondent number 4 would submit that the fourth respondent has worked for more than a year and she has been transferred to some other center, Anganwadi center, and therefore her appointment should not be disturbed. Full stop. Next para. This court is concerned about the appointment which was required to be made to the post of Anganwadi worker at Withdrawal in terms of the extant notification. Full stop. Having regard to the finding herein above, we are of the considered opinion that the candidature of the appellant herein could not have been disregarded. Full stop. But it cannot be a direct appointment now because there are 4 other candidates who are eligible. We do not know. From amongst them, they will have to reconsider. ignoring this fourth respondent. Please.
She is the widow. First priority has to be given to her.
I'm widow, my lord, I'm come under first priority, other than fourth
Third.
person,
It has
and
to be-
I'm my percentage also 64, my lord.
Third
See,
priority.
all that decision we cannot take now. We'll have to
Yes, sir.
direct them to reconsider, ignoring this fourth respondent. And if the appellant has got the highest merit and under the priority of eligibility, then she can be considered. Illa.
Age ayatante.
Illa.
No, the subsequent fresh notification to be quashed, my lord.
The
Well, first notification, they're not
Applicant.
challenged. Without challenging. how-
also found to be a widow. Full stop. There are 4 other candidates in terms of the resolution of the committee, other than the appellant and the fourth respondent. Full stop. Since we have come to a conclusion that fourth respondent is not eligible for consideration, having regard to the fact that she does not belong to scheduled caste category, we proceed to pass the following order. 1, the writ appeal is allowed. 2, the impugned order dated 12/7/2022 at annexure H is washed and set aside. Full stop.
Otherly serial number 1, my lord, in respect of Utnal village.
In respect of serial number 1, Utnal Anganwadi Center is concerned. Next para. The appointment committee is hereby directed to reconsider the application of the appellant herein along with 4 other candidates
That's on submission, ma'am.
who are found to be eligible for consideration. Full stop. The committee is once again directed to have regard to the basic fact that the candidates should belong to scheduled caste category. Full stop. Thereafter, the other list of priority as found in paragraph number 6 of the notification dated
2/2022.
2/2/2022 can be applied. Full stop. The committee shall pass necessary resolution and thereafter orders of appointment shall be passed by the competent authority. Full stop. The entire exercise shall be completed as expeditiously as possible and at any rate within a period of 4 weeks from the date of receipt of a copy of this order. Full stop. Ordered accordingly.
On submission ones.
ಅದೇ ಇದೆ. The subsequent notification.
That is not challenged, my lord.
ಅಲ್ಲಲ್ಲ
Consequent.
ಮಾಡಕ್ ಬರೋದಿಲ್ಲ because now this candidate, the consideration of the previous application has to go on.
That's true, my lord. He has to make the application for quashing that notification. There is no
Yavdu?
prayer.
How can you make appointment, sir, when it is vacant and we are directing it to be filled among the
That is
5 candidates.
ಅಲ್ಲ in lieu of that your lordship direction my lord
Yeah.
ಅಷ್ಟೇ ಹೇಳ್ಬೋದು.
It will not survive for consideration. It cannot be issued.
ಹಂಗೆ ಹೇಳ್ಬೋದು.
ಆಮೇಲೆ ಅಲ್ಲಿ ಇನ್ನೊಂದು ಸೇರಿಸ್ಕೊಳ್ಳಿ.
During the pendency of this appeal. Notification.
The consideration of the applications filed by the applicant along with the other 4 candidates who are found to be eligible will be considered in terms of the information provided by the candidates in terms of the said notification dated 2/2/2022. And their applications cannot be rejected on the ground that they are beyond the age of recruitment at this stage. Full stop. Next. The subsequent notification dated 9/10/2024 issued by ಯಾರಿದು?
Deputy Director, Child and.
Deputy Director.
Deputy Director,
List number 2 my lord.
Women and Child Welfare Department, Vijayapura, insofar as Hitnal
village.
Anganwadi Center is concerned, is quashed and set aside. Please.
In lieu of that notification my lord, so many application is received. That is my lord, that is placed before the committee.
Already stay was granted. After granting stay, my lord, they have issued me.
We don't know my lord.
These are
They also may come to the. my lord,
Yesterday they have issued me.
They also may come to the filing the writ petition my lord. We don't know.
Let them come.
Yes.
Let them come. So what? ಅಲ್ಲಿ ಅವ್ರನ್ನ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿ ವೇಕೆನ್ಸಿ ಕ್ರಿಯೇಟ್ ಮಾಡಿ ನೋಟಿಫಿಕೇಶನ್ ಇಶ್ಯೂ ಮಾಡಿದ್ದಾರೆ.
ಟ್ರಾನ್ಸ್ಫರ್ ಅಂದ್ರೆ ಹೆಲ್ತ್ ಗ್ರೌಂಡ್ ಮೇಲೆ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿ.
ಏನಾರಾಗ್ಲಿ ಫಾರ್ ವಾಟ್ ಎವರ್ ರೀಸನ್ಸ್.
That is vacant now.
Now since we have directed that their applications have to be reconsidered for appointment here, there cannot be a fresh notification.
ಅಲ್ಲಿ ಒಂದೇ ತರ ಅಂಗನವಾಡಿ.
Vacancy
sir.
vacancy ಇದ್ದಿದ್ರಿಂದ they have issued this notification. Now since we have directed that it has to be reconsidered, there is no vacancy and it has to be considered in terms of the previous notification.
That's true. my lord. But
Yes.
till then my lord, this fourth respondent may be permitted to work my lord. Because my lord, she is already my lord.
ಏನು ಹೇಳೋದು? ನಾವೇನು ಹೇಳಕ್ಕಾಗಲ್ಲ. Yes. Starting ಅಲ್ಲಿ delay control. Please. ಅಲ್ಲ ಪರವಾಗಿಲ್ಲ ಬಿಡಿ, ಅವ್ರು ಕೊಡಿ, ಆಮೇಲೆ ಇಟ್ ವಿಲ್ ಬಿ ರಿಟರ್ನ್ಡ್ ಆಫ್ಟರ್. Yes.
Serial number 14, Deepak V. Barad.
My lord, in this case, I undertake to file power for respondent number 2, my lord.
Learned Counsel Shri
Kripasagar Patil
Party undertakes to appear for
respondent number 2.
respond number 2.
My lord, I seek for a week's time. My lord. Compliance is already made. I'll file along with the affidavit.
This application is filed for revival
Revival, but it is as per the earlier order, it has already been complied.
at the request of Learned Counsel Shri Kripasagar Patil. Release this matter on
Next week, on 21st or 22nd.
21st of November.
Please, madam.
Serial number 15, Preeti Patil Melkundi.
Service company challenge liability, it's 29-day delay in the above matter.
Huh?
Delay is in 29 days. Delay may be kind and first for admission, delay is there 29 days.
Payment.
Insurance
of
company.
payment.
Yes, my company, sir, company. Challenge liability only act policy is there, madam.
Act policy.
Yes, my liability only act policy is there.
50% payment may be released. 50% payment may be released.
ಅಲ್ಲ ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ರು we will not permit you to withdraw
Liability act policy is, sir, that's not so.
because they are saying no, we have no liability. Notice no
Already serve ಆಗಿದೆ, sir, all
ಆಗಿದೆ.
ಆಗಿದೆ, sir. Delay ಕಂಡು admission.
Order on IA number 1 of 2024. Delay of 29 days in filing the appeal. condoned. Having been satisfied with the explanation offered by the appellant. ಇಷ್ಟೇ ತಾನೆ?
Yes, sir.
Call for
Records.
trial court records.
Much.
Admission matter, CL number 16, Venkatesh C. Mallabadi. Venkatesh C. Mallabadi.
It appears they are remarried, my lord. My client is not lifting the phone. Yeah, I got information that she is married.
Matter is called out. There is no representation for the appellant. Release this matter on 25th of November. Yes.
CL number 17, J. Augustine.
Matter is called out. There is no representation for either of the parties. Release this matter on 26th of November.
CL number 18, Ratna and Shoyogima.
Matter is called out. There is no representation for the appellant. Release this matter on 26th of November.
CL number 19, Anand Ture.
Lord, the parties have arrived at a compromise, my lord. They have come with the party petitioner has come along with the DD in terms of the compromise, my lord.
Bandidara.
Bandidara.
Huh?
ಬಂದಿದ್ದಾರೆ ಮೇಡಮ್.
Parties have come.
Filing a compromise petition.
Yes, my lord.
Today.
Petition is a short time, afternoon we'll file, my lord. It's
Afternoon.
a memo. We'll file a memo because they've got a DD.
Afternoon illa, sir. You want it on Tuesday, we'll have it on Tuesday.
Please,
Huh?
please.
At the request of learned counsel on both the sides, release this matter on 19th of November.
Please.
CL number 20, PS
ಎಲ್ಲ
Manipal.
ಅರ್ಜೆಂಟ್ ಮಾಡ್ತದೆ. You are adjourning all the matters. Yes.
Kindly post on 26th, madam.
Huh?
26th.
Number 20.
20,
Kindly post on 26th.
26th.
Senior will be physically appear.
ಯಾರು?
Senior. Yes, madam.
At the request of learned counsel for the appellant, release this matter on 26th of November.
Last time, serial number 1826. Serial number 1826.
Ah,
That is 21 and the other, not instead of
26.
26, instead of 21, 26.
26th ಹೇಳ್ರು.
Please, yaar, 21.
Ah, yes.
CL number 21, SS Aspalli.
Any date.
Release this matter on 21st of November.
CL number 22, Preeti Patil Melkundi.
Just mind the insurance company challenging liability and risk. That's why the policy conditions and breach condition, terms and condition variation of policy and.
Ah, why is it coming up? For what it's coming? up?
Allah stay, sir. Admission stay.
Huh?
Stay, man.
Admission.
Admission stay.
No delay.
No delay.
Huh?
No delay.
Issue notice to the respondent.
Yes, ma'am. Stay means.
That there shall be an ad interim order of stay of the impugned judgment and award in MVC so and so till the next date of hearing, subject to the appellant depositing 50% of the award amount fixed with the reference court within a period of 6 weeks from today.
Meanwhile, call for records.
Call for trial court records.
Much of.
1 to 5.
Huh? ತಗೊಂಡಿದ್ದಾರಲ್ರಿ
ಅಲ್ಲ ಅದು ನೋಟಿಸ್ ಅಲ್ಲದೆ ತೊಗೊಂಡಿದೆ ಸರ್ ನೋಟಿಸ್ ದಾಟ್ಸ್ ಇದಾಗಿ
ಆಗಿದೆ.
ಅದು ಹಾಕಿದ ವಿತೌಟ್ ನೋಟಿಸ್ ಹಾಕಿಬಿಟ್ಟೆ ವಕಾಲತ.
ಹೌದಾ?
ಹಾ ಸರ್.
All of them.
ಎಸ್ ಸರ್.
ಹಂಗಾರೆ ಸ್ಟಾರ್ಟಿಂಗ್ ಅಲ್ಲಿ learned counsel ಶ್ರೀ MM Alur has entered appearance for response number 1 to 5.
600 notice of.
Issue notice to response number 6. Right.
B group matter, CL number 23, Mahantesh Patil.
Release this matter on 27th of November.
CL number 24, Government Advocate.
I appear for respondent matters.
Release this matter on 25th of November.
CL
I
number
appear
24,
for respondent matters.
Yes,
My
yes.
presence may be taken.
Yes, yes.
CL number 25, final hearing, Ashokar Kalyan
But
Shetty.
to appear for the appellant.
Release this matter. 2012.
ಹೌದು ಅದೇ ಮ್ಯಾಟ್ರ್ ಸ್ವಾಮಿ ನಿನ್ನೆ ನ್ಯಾಷನಲ್ ಹೈವೇದಲ್ಲಿ ಆರ್ಡರ್ ಆಗಿದ್ದು ಅಪೀಲ್
On 20th of November.
21st.
21st.
ಅದು ಯಾವತ್ತೈತೆ ಅದು
ಇದೇ ಕೇಸಲ್ಲಿ ಫಸ್ಟ್ ಮೆಲಾಟ್ಸ್ had passed the order stating that ಮೆಲಾಟ್ಸ್ national highway ಮೆಲಾಟ್ಸ್ is not liable to.
ಇದ್ರಲ್ಲಿ ಆಗ್ಲೇ ಆರ್ಡರ್ ಪಾಸ್ ಆಗಿದೆ.
ಆಗಿದೆ and ಮೆಲಾಟ್ಸ್ have ordered for deletion of national highway from the array of respondents.
We have to go on the merits of
Merits of the case, whether I am entitled for.
Yes,
Seal number 26 additional
21st.
SPP.
21st.
Please.
26 additional SPP.
Release this matter on 27th of November.
Seal number 27 RS Siddhapurkar.
27th of November.
Seal number 28 additional SPP.
28th of November.
Seal number 29 additional SPP.
28th of November.
Seal number 3030 Basuraj Karaddi.
When do you want? 21st?
Please.
Huh? Release this matter on 21st of November.
Seal number 31 Rajendra C Desai.
For the appellant in the connected. Sir, appear.
ಏನ್ ಇಷ್ಟೊಂದು connected matters?
ಮೂರ್ accused, 3 accused have filed 3 separate appeals challenging their order of. Same.
2016
ಹೌದು.
for final hearing.
House.
Paper books ಎಲ್ಲ ಬಂದಿದೆ.
ಆಗಿದೆ, they are on bail, all the accused they are on. bail.
Released these matters on 28th of November.
28, please.
Seal number 32 Jidege Kailas C.
Release this matter on 25th of November.
Seal number 33.
One submission, my lord.
Show
In
your
this case, before lower court, we have given certain rulings. They are in the records. I have those and Xerox and give it. Rulings. which ನಾವೇ ಕೊಟ್ಟು ರೂಲಿಂಗ್ಸ್ ರಿಕಾರ್ಡ್ಸ್ ನಲ್ಲಿ
You
ಅದಾವ.
want to note down?
ಅದನ್ನ ಜಿರಾಕ್ಸ್ ಮಾಡ್ಕೊಂಡು ಮತ್ತೆ ಕೊಡ್ತೀನಿ.
Xerox ಅಲ್ಲ, you note down the citation.
ಅವು ಸಿಗ್ತಾ ಇಲ್ಲ, ಲೈಬ್ರರಿಯಾಗ ನೋಡಿದೀವಿ, ನಂಬಲ್ಲಿ ಇತ್ತು. ಅದಕ್ಕೆ ತಾವ್ ಒಂದ್ ಮಾತು.
ಬಟ್ ಇಲ್ಲಿಂದ ಹೊರಗಡೆ ಹೆಂಗ್ ತಗೊಂಡ್ ಹೋಗ್ತೀರಾ?
ಅಲ್ಲ, ಇಲ್ಲೇ ನಮ್ ರೂಲಿಂಗ್ ಅದಾವ ಅವು.
ಸರಿ.
ಪ್ರಿಂಟೆಡ್ ತಾವ್ ಹೇಳಿದ್ರು ಅವ್ ತಗೊಂಡ್ ಜಿರಾಕ್ಸ್ ಮಾಡಿ ಕೊಡ್ತೀವಿ. ಅವು ಏನಾಗ್ಬಿಟ್ಟವ, ಲೈಬ್ರರಿಯಾಗ ಅವು ಹಳೆ ರೂಲಿಂಗ್ ಸಿಗ್ತಾ ಇಲ್ಲ. ಅವು ಪ್ರಿಂಟ್ ತೆಗಿಬೇಕಂದ್ರ.
ನೋಡ್ರಿ ಸುರೇಶ್ ಅವ್ರೆ, ಈಗ these are something that copies can be taken. You please give in the citation and can be taken. ಆ ತರದ್ ಏನಾರು ಇಲ್ಲ ಅಂತಂದ್ರೆ you see how it can be, copy can be given. Yes.
ಜಿರಾಕ್ಸ್.
Seal number 33 Ratnayan Shivayogi Mutt.
Release this matter on 25th of November.
Seal number 34 Manvendra Reddy.
Release this matter on 26th of November.
Seal number 35 Sangan Goda V. Biradar.
27th of November.
Serial number 24, my lord.
24 25th
23 ಎಲ್ಲ ಡೇಟ್ಸ್ ಕೊಟ್ಟಿದ್ದೀವಿ. 23 it may be taken on
27th of November.
27. Seventeen ಯಾವಾಗ ಹೋಯ್ತು ಸರ್?
ಅದೊಂದು ಡೇಟ್ ಇದೆ. ಅಕ್ಕಂತ ಕೈಲೇ ಬರ್ಬಿಡ್ರಿ ಸರ್.
ಮಧ್ಯಾಹ್ನ ಬರಲ್ಲ.
ಇದು ಡಿಸ್ಪೋಸ್ ಡೇಟ್ ಹಾಕು, ಫ್ಲಾಗ್ ಹಾಕ ಅಂತ ಕೊಟ್ಟೆ. ಫ್ಲಾಗ್ ಡೇಟ್ ಅಂತ ಒಂದು ಫ್ಲಾಗ್ ಡೇಟ್ ಮ್ಯಾಟ್ರು ಅಂತ ಮಿಸ್ ಮಾಡ್ಬಾರ್ದು ಅಂತ.
ಇದು ಹತ್ತಿರೋದು
19ಕ್ಕೆ ಹೋಗ್ಬಿಡ್ತಾರೆ ಸಾಹೇಬ್ರು ಪಟ್ಟಣ ತಗೋ. ಸರ್ ಬರ್ರಿ ಆ ಕಡೆ ಬರ್ರಿ.